Thank you all for coming today. Welcome to Law and Licensing. I'm Linda Hanson. I'm the chair of Law and Licensing, and we'll go around and have everybody introduce themselves. Carol, you want to introduce yourself?
Carol Laird, District 7. Michelle Bolter, District 15.
Angie. Elisa Ellis, District 12.
Angie Stallings, staff for the board, Deputy Superintendent of Policy and Communication.
Thank you. All right. Is there anybody out there who is representing organizations who would like to be introduced today? Tracy?
Tracy Watson, representing Utah Education Association.
Okay, thank you, Tracy. Yes.
Jennifer Boulder, Utah Association of Public Professionals.
Okay, thank you, Jennifer.
McKay Jensen, the USBA, Utah State School Board.
Thank you.
Michael Syndergaard, Mountain State School Board Repository.
Okay, great. Thank you, Michael. Anybody else? Is there anybody here who's just here on their own who would like to be introduced? Usually people don't, but all right. Thank you all for coming. All right, board members. The first item on the agenda is the approval of the minutes. Are there any changes? If not, we need a motion.
No, you go because I'm still logging.
Oh. I move that we approve the minutes for law and licensing.
Okay, we have a motion to approve the minutes. All in favor? Aye. Any opposed? Okay, the minutes pass unanimously. All right, our first item of business here is R277621, District of Residence, which is a new rule that we're going to be looking at.
All right, and you may remember that we spoke or reviewed this rule a couple months ago. The rule is being drafted in response to a bill that was passed this last session, HB 125, Student Residency Amendments, and the rule clarifies the process by which a parent may seek essentially an appeal and assist if the districts need to have a process in order for a parent to get an appeal up to the State Board of Education. This would be the process to follow. If the districts can work these issues out amongst themselves, there's no reason to involve the board. This process is only in place in the case that the board does need to get involved in some of those decisions about when a student might qualify under the statutory provisions of getting or receiving services from an alternate district or a district outside of the district where their parents reside. So we reviewed 621, as I said, a couple months ago, and we made the change that was requested to have the board, the local school board, approve those requests. We solicited feedback, as the committee suggested, to see if whether the local school boards wanted to actually approve those requests or whether they would want the superintendent of the district or maybe another designee. Most, if not all, of the feedback that I received was that local school boards likely wouldn't want to approve those requests, mostly because they couldn't get into the details of student information in a public meeting. However, what we did is kind of a compromise, which states that the local school board or a designee would approve those requests. That way, if a board would like to individually approve those requests, either through some sort of a consent calendar or other process, they could, or they could also designate their superintendent or one of their assistant superintendents as the person who reviews the requests and makes those approvals or denials. And so I don't know if you have any questions about that, but that was essentially the compromises made. It is still the local board's decision or authority to approve those, but they may delegate that authority to their superintendent or somebody else in their staff.
Okay, we're looking at revision 1. Yeah. Is that right?
Yeah. And then revision 1 includes some recommendations that were raised by board member Lear. And I reviewed both the original draft as well as revision 1 with some select superintendents. They unanimously preferred revision 1, just if you're interested in that. So you can see some of the changes or the additions to the rule are mostly what I would call clarifications. I think that the first revision or the original draft, the assumptions are as stated here, but Board Member Lear thought, and Ben and I agreed, that these clarifications would be helpful. So you can see that it just is helpful for a parent to know that while a district, an alternate district, is determining whether or not they're going to provide them educational services or approve them, that the originating district needs to continue to provide services. Also, once an alternate district makes a decision to allow services, that the student be enrolled immediately. There's also some clarifying language below that the alternate district is not responsible for transportation from the health facility to wherever the student is going to be receiving educational services. And then also a clarification that an alternate district can periodically review to make sure that the student still qualifies. So, for example, if the student leaves the health facility or the substance abuse facility and they no longer qualify under the statute, the district could review that from time to time to make sure the student still qualifies under the statutory provision. So do you have any questions about that?
I don't have any anybody that's signed up from the public to make comment. So board members, I think it's up to you to either make comment or a motion. Carol?
I just have a couple of brief comments. I appreciate that the staff was responsive to the concerns that I had, because I'd heard some of those from the school districts I work with, and I think that some of this could be problematic for smaller districts and charter schools. I guess it doesn't apply to charter schools expressly, and there are 41 of them, so there's certainly a range of sizes and resources. So I think these changes will help. I just want to say, I felt, Angie, that this was more of a significant change than previously, because residency had always been established where the parents lived, and that was the responsible party. And yes, districts often work together, and sometimes it didn't work, and I know that's what created the impetus for this rule. But I'm going to be watching carefully and see if it works both for the sending and receiving district and for all the parents involved, because it certainly affects the parents in the communities where these students move if there's a significant use of resources. And I don't want to sound uncaring at all, but there is a district of residence where the parents live that could serve these kids. And so we're giving a considerable opportunity, I think, to parents to choose their best situation for their children, but sometimes at considerable impact to the community. So I want to watch carefully and see if this makes it a more smooth kind of process or if it causes more problems. But I do appreciate the changes, and I think the clarifications were helpful to me. So that's all. I'm good about, do I need to move to adopt revision 1? Then can I go ahead and do that, Linda? Mm-hmm. I move then that we adopt revision 1 of R277-621 and send it to the board for further consideration next month.
Okay, the motion is that we approve R277-621 revision 1 and send it to the board and first reading.
For us for first reading.
For first reading, and send it to the board for further action next month. Is there any further comments? All in favor? Aye. Any opposed? Okay, that passes unanimously.
Can I make just one comment?
Yes, go ahead.
I just wanted to, and I know we don't have very many people here who probably aren't listening, but hopefully districts know that if they can work things out or they can solve these problems, they do not have to use this process. They can work out arrangements, payment arrangements, time arrangements amongst themselves. But this process is only when a parent feels like maybe they aren't being served by the districts, and then they need to involve the board. And so hopefully the districts will continue to solve these problems on their own and they won't need to involve the board.
Okay, thank you, Angie. Okay, let's move on to R277211, disciplinary letters and dismissals, and this is an amendment. Hi, Ben, will you introduce yourself to us?
Yeah, Ben Rasmussen, Director of Law and Professional Practices. The change we've made here to R277211, or that we're proposing, deals with the disciplinary letters we send to educators after an investigation. It's been UPAC's practice to copy those letters to the school district that the educator works for that reported the misconduct. This would formalize that in rule that that's our practice. And so that's why this amendment's been proposed.
Okay, thanks, Ben. Any questions on that before we go to public comment? Yeah, go ahead.
So how long have you been doing this without a rule in place, Ben?
I've directed my staff to do this since I've been here.
So 3 years-ish. And there has not, just to clarify, there's not ever been anything official in place that gave notice to the individual that this was happening, right?
To my knowledge, no.
And so just to kind of make a comment, the basis of due process is a person has a right to notice and a person has a right to a hearing, just the very most basic due process. So technically, there's some information going to a district that the individual has had not any ability to influence.
Well, the educator is part of the investigative process. Our UPAC attorneys interview them as part of that, but we don't give due process on letters of admonishment or letters of warning.
Even though there was no notice that they went to the individuals, to the districts.
Well,
Even to
it's
form
on the letter that we've copied.
One thing you didn't mention is they also go to the districts of if a person's left the district for some reason, their own choice or the districts, they also would go to the former district.
Yeah, if the district reported the misconduct, that would have been.
So that would also influence the reputation of that employee.
Carol,
former
let's
employee.
go
Right.
ahead and let Tracy make her public comments, and then we'll go back to board discussion.
Okay, just wanted to clarify a couple of things at the outset.
Okay.
I think that was all. Just 1 second, Linda. I just wanted to make sure one more question, please, that might set the stage
Okay.
for other comments, and that is, so did you just decide to do this on your own?
This was a policy decision. I've been asked to draft it to put it in rule, yes.
No, but you decided to start the process.
Initially, this
on
was my call, yes.
Thank you.
Okay, Tracy?
Tracy Watson, Utah Education Association. So yeah, I mean, I think that there are some problems with the current practice that the rule doesn't really fix. So I don't want to harp on it, but it's a change in practice. So it wasn't formally, these letters weren't sent to the district, okay? Then the practice changed, but the rule didn't support that change. So one of the problems is that there's some questions procedurally what you're going to do. If you pass this rule and accept the changes, then basically the agency is admitting that it's been doing something without notice and due process up until the point the rule goes into effect. So if you pass the rule to the board for next month and the board accepts the rule, then are you going to continue the practice before the rule becomes effective? That's going to be a problem. I think also including the former employee is problematic because the former employer, it no longer has jurisdiction over the employee. So why would you send something to a former employer that's no longer involved in this employment relationship? That kind of could set up a privacy challenge, okay? And the changes to this rule can't happen in isolation. There are other changes that would need to be made. So, for example, right now, the definition in R277210 says that the letter only goes to the educator. It does not say that the letter will also go to the LEA. So if you accept this change, you've got to change the definition of the letter too, both the letter of warning and the letter of admonishment. And then up to now, as Carol pointed out, and that's why we can agree on certain limited things, because it's a due process issue. Up to now, the educator who receives a disciplinary letter, a letter of warning or a letter of admonishment, hasn't had any due process, complete due process, because the letter just stays in the UPAC file. They don't have a way to challenge what's in the letter. They don't see what's in the letter until they get the letter. So yes, they are interviewed, as Ben admitted. They are part of the investigation. They are interviewed, but they don't see the letter until the decision is made and the letter is issued. And at that point, there is no ability to challenge the language in the letter or the decision. Once you send that to another agency, to the employer, it could have a collateral consequence, and that triggers the due process issue of the hearing. Because you can't just tell a district, put this in the employment file, if the educator hasn't had any opportunity to be heard. Now, it may not need to be a hearing process that's as extensive as when there's a reprimand or a suspension, but there does need to be some hearing process, or you've done something, you've created a negative collateral consequence without any due process. And right now, you would have a conflict, just passing this rule by itself, you'd have a conflict in the notice provision, because the definition doesn't give any notice to the educator that this will be in the file. While this rule allows that to happen, once it becomes effective, what are you going to do with the practice until the rule becomes effective? Are you going to stay the practice until the rule becomes effective? Or, because otherwise, you're like, it's kind of a due process nightmare right now. So I hope those comments are helpful.
Okay, does anybody have any questions for Tracy? Okay, thanks, Tracy.
Oh, sorry, I do. I apologize.
Okay, Lisa.
I just turned my light on. I didn't
That's
raise
okay.
my hand. So I'm looking at the 210. And anyway, it's different than what you're showing me, because I'm looking at the rules.utah.gov. Angie.
I've got 210 pulled up on the screen.
Okay, but the version that I just looked at, it's just so small.
So,
The one that's on rules.utah.gov doesn't say to an educator. Look at
It
this.
says means a letter issued to a respondent by the board.
This wording is slightly different than the one.
Yeah, that's what I've got up there. Means a letter issued to a respondent by the board as a result of an investigation into
Okay. Well, the version Angie showed me
an
just said
allegation
the
of educator
well,
misconduct.
I showed her the definitions of letter of admonishment and letter of reprimand.
Oh, so I'm in a different place.
And what letter of reprimand says is a letter sent by the board to an educator, and then it goes on for misconduct that provides specific, et
So
cetera.
it's just a different place.
Then the other one, letter of admonishment, says is a letter sent by the board to an educator cautioning the educator to avoid or take specific actions in the future. I mean, I'm not
I see
the
it
attorney
now.
for the board, so I think Brian can opine. I can see Tracy's argument. I mean, it's definitely a valid interpretation.
Thank you. That doesn't happen very often.
But I could also make an argument that this is a definition that describes a letter in general, and it says the letter goes to an educator to inform an educator, and that there would need to be other provisions, or that there's other circumstances that would govern how that letter is used. I think so.
It's kind of clear, though, if you follow it through. I mean, if you look at the definition of letter of reprimand, you look at the definition of suspension, those kinds of things, you'll see that those letters go to the district, that the notice of the action goes to the district. Under the definition of warning and admonishment, there's nothing that indicates that there's a communication between UPAC and the district.
Okay, any other questions for Tracy before we have discussion among board members?
That's okay.
Lisa?
So I listened to your explanation, and I appreciate you bringing it to our attention. I'm just trying to understand exactly what you're seeking here, because it sounds like you don't want us to continue the practice that's been happening without, so you're you're requesting that we take that out and stop the practice. Is that what I'm hearing?
Well, I mean, there's a due process issue, right? So the practice was changed, but the rules didn't support it. So by changing this rule, you know, I just want to go on record that you know that you're opening up yourself to challenges for the letters that have been sent to the district during the period of time before this rule goes into place. What I'm not saying is that you can't do this, right? You can do this. You absolutely can do this, right? But it's problematic. If these letters are going to go to the district, there needs to be some type of hearing. The educator has to have some input in what's in that letter, some ability to challenge it. Yeah.
Okay, well.
Thank you.
Let's ask Brian, our attorney, to give us a little bit of input. Thank you. Thank you, Tracy.
You're welcome.
That works. Hi, Brian Quesamayor from the AG's office. I came in kind of halfway or at the tail end of the discussion, but from what I understand, Tracy's concern is a due process concern, and what she said that the board can do it. However, the board is opening itself up or exposing itself to due process. Due process is generally you have to give notice to a person, and they have to have an opportunity to defend themselves, opportunity to examine, respond to their accusers. That's due process, obviously, in the Constitution. So here, though, sending a letter to the school district about an educator, I don't quite see how that relates to due process. So I'm at a loss there, and maybe Tracy and I can talk a little more detail about that concern. What is the window of time, though, from when, or how many months do we have before the rule actually goes into effect?
All right, can you say that one more time?
How long do we have before the window of time here?
So if the committee adopts this today on first reading, then the board in about 3 weeks, when we have our November meeting, could adopt it on second and final reading. Then I would file it.
3 weeks.
And then so it's essentially about January 7th would be the earliest at this point. Unless we did an emergency rulemaking, which I don't think this necessarily qualifies.
So the window of time is between now and January 7th?
Yeah.
Yes. About. So
It could be longer, absolutely.
If we want to, we could
Right at this
ask to
point.
hold it in committee.
But the earliest right now would be kind of the beginning of January.
Elisa?
So Tracy's argument, though, is that by adopting this rule, and then instead of just a month lag time, there would be 4-month lag time where anyone that was brought before, she's saying that we could open ourselves up for, I don't know if she was saying referencing litigation or just complications. But I also want to thank Ben for bringing this to light, because I appreciate any time we recognize that we're doing something that we should have as a rule or a policy. And I'm not scared of saying we've been doing something wrong, because there's a lot of things that I see that we're doing that we haven't been putting necessarily of having a policy in place. So I think that correcting those is okay to do. But I would like to examine a little bit further the arguments that Tracy is making.
And so to a certain degree, you want to look at kind of risk and are we risk takers, or we want to take a more cautious, conservative? So when you go to Las Vegas, you put the quarter in the
Privacy,
machine.
you're not.
So if you want to be cautious, out of an abundance of cautious on this from now until January, whenever, then you can decide to not send those out. But if that doesn't concern you, and the risk in your view is minimal, de minimis, then keep the current practice until the end of January. But I think, and maybe I missed your comments, Ben, if you've
Go ahead.
put on
Well,
this.
I think the one thing we're missing here, we're talking about the due process issues, and that's very appropriate, but this is also a public record issue. This isn't as if I'm sharing private information with these districts. This is employees or former employees of this district, and we have open records laws which make this kind of thing public. I don't think I need the rule personally to share this with these districts. I'm just telling them what we're doing with an investigation that they've, in most cases, referred to us. We're doing this out of an abundance of caution just to put the educators on notice of that.
Okay, Angie, then Carol.
And I think mostly I was going to make a similar statement to what Ben said, and maybe part of the research that Brian does is whether or not we agree. I think that Tracy and Board Member Lear have raised some issues where they would argue on one side that what Ben's practice has been is not permissible without the law, without the rule. But I think there's an argument to be made, and obviously Ben felt there was a different interpretation, which was that he didn't need the rule because there are other provisions. It's, it's a public document. It's oftentimes these are districts who have referred these actions to UPAC. So it may be good for Brian to do the research.
I'd love to do that. Yeah, I'm happy to get a memo here to the committee on that.
Okay, Carol.
I think it's really important to be said, proximate to Ben's comments, that not all of these letters are completely public. If one of these letters addresses, and it's subjective, it's you writing the letter. So if one of these letters addresses health problems that the educator had, or addiction issues, or treatment issues, or other kinds of things, and then goes to a former employer, that isn't a public record without redaction or without consideration. So I think that's a really important thing to note. These are not point blank, carte blanche public records. And I think that the fact, and also in response to Elisa's comment about not being afraid to correct things, I typically would agree with that, but this was called to the attention of numbers of people months, if not years ago. And it's only under pressure now that a rule is put in place to justify a practice, which was really always something that this board has not favored. That we don't do the practice first and the rule second, because that doesn't give fair notice to all the individuals out there. I think another important point to make is one of the reasons that I think sending the letter of reprimand to the district, the employer, distinguish that letter from the lesser letters, the lesser discipline. Now why don't we just have all one letter? Because everything happens the same with the letter of reprimand, the letter of warning, the letter of admonishment. And the idea with the letter of admonishment and warning initially, even when the rules were rewritten, was that these would help the educator see what she was doing wrong, help her improve, without making a big public statement about it. Now we might as well just have one letter, which would probably be my motion depending on what happens, because there's no distinction about ending this. If Brian's going to do some research, it sounds like we'll be waiting on this, but I would like you to think about maybe a compromise where the district or the former employer is notified that the case is closed with a letter of warning or with a letter of admonishment, but not send the letter to that LEA. That would provide some protection, some privacy for the individual, and also maintain some of the distinction of the original purpose of different kinds of letters. So I'm not proposing that now, but I'm just saying as you research it. And I want to say publicly as well that I am really troubled that this practice has continued when it was brought to the attention of a number of people, and I think it does harm to people's employment opportunities when there was no rule in place, but a practice continued.
Okay, thank you. Michelle?
I just have a question. Are these letters grammable?
Yes.
So all the letters that are written...
Carol's right that some of it would possibly be redacted, but they're all subject to grammar.
Okay, so they are all... So the district, if they knew of a letter, could request to have it.
Okay. One other comment that I want to make, and then we'll go to you, Brian, is that, it's possible that it would be a good thing for the district to get this from the educator's point of view, because if they're getting a lesser, like a warning or something else instead of a greater type of discipline, then that's showing the district that it wasn't deemed to be that severe. So I think that's You know, it's all in your perspective,
But
right?
the educator could then give it to them.
Okay, Brian.
Would that be helpful if I did some research on that due process legal issue and then got you a memo
Yes.
on that? Okay.
I think we'll.
And I want to clarify what I would hope Brian would also research. Can I do that?
Go ahead.
I'd also like to know about the ongoing practice of doing this, despite the fact that there was no rule.
All right, we'll see what I can find.
Okay, without objection, we'll hold this rule in committee until Brian comes back with his report. Elisa?
I don't have an objection. And in general, I agree with Carol's concern that practices are put into place without board rule, but then at the same time, we do have an office to run. And so if employers feel like they can do nothing without board movement, anyway, so I don't know exactly how to handle this, because there's a lot of instances where things are happening, and I don't agree with a lot of them. But I also can't micromanage every little thing that happens.
Can I clarify that, Linda? Because I don't want you left with that impression, or the public left with that impression. I'm saying when something so influences a person's career, that if the letter goes to a former employer, if it goes to a current employer, when the person's understanding was that that wasn't going to happen, for better or for worse, the individual may not even know that the employer has that information about her. So I think this is not just another administrative practice. I think this is something that might interfere with or influence a person's full career, not just a job. That's why I think it's so important.
Okay, thank you. We will move on to the next one, which is school nurse health updates. And I understand that Lillian's going to be coming and talking to us about that. Thank you, Ben. Thank you, Brian.
Well, until we get to the election part, maybe.
Okay, thank you for coming.
Thank you. Lillian Sosi Jensen. I'm Educational Coordinator in the area of Student Advocacy Services. And here today just to review some items that we wanted the board to be aware of. In Statute 53A11-204, it addresses school nurses in public schools. It is very limited in description. And so as we have found, and I'm going to let Betty Sue introduce herself as she speaks today. Betty Sue has, she's actually from the Department of Health. The Utah Department of Health employs a school nurse consultant who is a resource to our schools. She comes to our agency about once a week. And Betty Sue is fairly new, and I appreciate her expertise, and that's why she's going to speak to this today. But in her role and expertise, we found that we need a little bit more guidance. And there are several items that we would like to have up for review in the next several months that need to be addressed, including a new board rule as well as renewal of the MOU. So with that, Betty Sue, if you'll introduce yourself, and I'll let you go ahead.
Betty Sue Hinkson from the Utah Department of Health, State School Nurse Consultant. So this law that Lillian was talking about, Utah Code 53A11-204, says, among other things, that it's recommended that it may be better for schools to provide nursing services to of one registered nurse for every 5,000 students, or in districts with fewer than 5,000 students, the level of services recommended by the Department of Health. And this was from 2002, I believe, but that recommendation was never made by the Department of Health. So I presented to them a proposal of what we would like to see. First of all, school nursing in Utah it is a little bit different than it is throughout the country. In the eastern part of the United States, there's usually one nurse for every school. there was a recommendation years ago that there be one nurse for every 750 students. So one nurse to every 5,000 students is kind of a broad recommendation. But we have many districts where it's one nurse to every 12 or 15,000 students. So this would just be kind of a guideline. And I did attach some information on that where based on different criteria, there needs to be more than just looking at the actual numbers, one nurse to every 5,000 students. You need to look at the health disparities. You need to look at the social situation in the classroom or in the neighborhood. And then you need to also look at the health acuity of those students. And so I do have, I believe I attached that, but there has been a little bit of a revision. The upcoming, the recommendation that I presented to the Utah Department of Health was that there be one registered nurse per school or several full-time registered nurses per school for those schools that have higher acuity. So our special ed schools would typically have more than one full-time nurse based on the health disparity needs. Disparity needs, or one full-time registered nurse for no more than 5 schools, and that would allow the school nurse to go and evaluate the delegation that is being done. So typically, the nurse isn't there to provide the one-on-one care that a student might need, a student with diabetes or a student who has spina bifida that needs to be catheterized. They can't be there for all of the students, and so they delegate those procedures, and the process of delegation requires supervision and evaluation. So this would allow them to go weekly to each of their schools to evaluate them. And then to directly address the statement, districts with less than 5,000 students would have kind of a varying recommendation, and that has been updated a little bit, and I can. Yeah, they're very, very small, but I don't know if. We have actually about half of our districts are smaller than 5,000 students, and so this applies to quite a lot of our districts. And so the recommendation would be anywhere between 0.1 nurse to 1 full-time nurse based on their specific needs. And then all the way up to 5,000 students, and my revised document has one nurse one FTE up to about 6.7 FTEs. And that's based on the first number, my revision. The first number is based on the 1 to 5,000, and the second number is based on the 1 to 750. That was the national recommendation. So that's the range. This is a very difficult process because we have some districts who do have a nurse in every school, but they are the exception. And so we don't want to offend those districts that have gone the extra mile to provide the staffing services that are recommended, but yet we also want to look at those districts who may only have 0.1 nurse for 3,000 students, which would not be adequate to serve the needs of those schools. So we're just looking to get input from the board to see how you would feel about there being an actual recommendation from the Department of Health before they approve this. They wanted me to present it to you to get any feedback from you.
Okay, board members, are there any questions before we go to public comment? Carol?
So I probably was a lazy listener right in the beginning. Were you're talking about this as just a recommendation to the health department, that then the health department wouldn't have any authority to make schools do this, but it would be a recommendation to schools?
That's correct.
Is that right?
Yes.
Okay, just wanted to.
And that was one concern they had. They thought it would open up liability if they did not meet that recommendation, but then it was also determined that it is a recommendation or encouraged and not a must.
Right, it's kind of double-edged. I wish it would be stronger, could be stronger, but I understand that. And I thought it's interesting. I just have to point out in reading 53A11-204, language that we eschew in our rules is throughout. It is strongly recommended that. It would be a good idea if. So I think it's maybe worth noting that it is done in legislation when we sometimes don't want to do it in our rules. But I appreciate your comments and thank you. Completely support your cause.
Thank you.
Okay. McKay Jensen has asked to make some public comment.
Thank you. I don't mean to take up too much of your time.
Introduce yourself first.
McKay Jensen from the State School Board Association. But certainly, school nursing is something that we've seen as enrollments have increased and those ratios have gone. We would be very supportive of a recommendation, certainly to districts, because I think it's also incumbent upon us to see the type of things that refer to school nursing are beyond cuts and bruises and accidents, but are a lot of our psychological and emotional problems are also referred to as school nurse, and those items are becoming overwhelming. In Provo School District, we've opted for a system of health clerks, which is CNA preferred. That can help evaluate, but is in the school, and is assigned to each of our schools, and they can refer to a school nurse, but can help work with social workers and everything else, because these problems are increasing. And so pursuing a way to inject Medicaid funding into this, and encouraging districts to provide greater services in this area is something that we're very much invested in for the well-being of students, and I'm sure you are as well. And we just really appreciate that attention.
Okay, thank you, McKay. Any questions for McKay? No? Okay, thank you. Oh, wait. Michelle.
Did you say that nurses could help evaluate whether a student has a...
So as those ratios of nurses to students have typically just increased, I'm sure, as you know, in Utah, those number of students without the number of nurses has not kept up. It's one of those below the line funding issues from the legislature that when you hear growth funding, it doesn't get. And so as that's gone on, districts have either just said, well, we'll just have the nurses visit the faculty, and the faculty will take care of it, or the secretary will get a little extra training. And we've opted to actually hire health clerks, which we can hire for less than full time, a little less education, but we require all the first aid certification, CPR certification, and prefer CNAs. So some education that can be there as a ready resource in our buildings, because we've recognized that our need is great. Certainly, we're conscious of our funding for that, and we can't provide a nurse for every building, but we need services, and so we try and add people in an efficient way so that we can make sure that that nurse is people tasked with providing health services in a building. There's someone actually assigned always, and that they can communicate with the nurse instead of just the secretary that's answering the phones or everything else, or just a teacher moving out of the classroom, because these needs are, in fact, increasing just in pure anxiety with some students, and this is certainly, there are the bumps and bruises and everything else, but there are many problems. For example, Steve Smith at BYU reports that BYU is part of our community, and he's the director of counseling services at BYU. 50% of their student population doesn't just self-report psychological issues. They have a diagnosis and a treatment plan. 50%. Now, wow. If you add...
Well, it is BYU.
It is BYU. But if you add issues of poverty or other things on top of that, this is the population. And anxiety and psychological issues are beginning to be biological responses to new environments that we have, and this is just increasing, and those are increasing burdens on the school nursing program.
Okay, thank you, McKay. Appreciate it.
I have one just sort of random question. Are you on the staff of the school district, or are you a board member?
I'm the board president at the Provo School District,
Okay,
but I am
thank you.
employed at Alpine School District.
Okay, all right. That's
So
why
I'm an
not totally
educator
crazy.
all the time.
Okay. I have the same cross to bear, so thank
Yes.
Thank you. Oh, you have her. Okay.
I think Michelle was trying to ask if the nurses in the school are diagnosing things or just helping, like, because you were talking about mental health issues, and so, yeah, and then you were also talking about just physical things, and so she was trying to ask you if they were diagnosing, and you didn't quite answer that question.
If, all they are doing are just a bit of triage. If this is a social worker issue, but we're trying to get intervention to the right person as quickly as possible, or the school nurse, or in the district, which I believe there are 2.5 for Provo School District of roughly 14,000 students. And so, but having that health clerk that is constantly engaged in those issues in a school, receiving training, receiving that person that can coordinate with the school nurse, that when the school nurse actually comes and does training, or this is an issue, or we're seeing this, be aware, they're more receptive to that than just the faculty of, oh, you should be aware of, we've had a whooping cough case in a school, and also make sure your attendance is up to date, and PD is, and all these other things. We have someone in our buildings, but they're not diagnosis, they're coordinating.
Okay, thank you. Let's see, Lillian, do you have anything specific anything else specific that you need from us? Have we given you enough information that?
But primarily, we wanted to just have your input, and if you'll see under key points that there are several items that need to be discussed, and we certainly did not want to overwhelm you in looking at, first of all, the staffing recommendations, and then looking at a new rule that would go into place that would look at matching funds for the school nurse program and grants. We do need a little bit more guidance, and that would help support Betty Sue in her role as consultant for the school nurses across the state. And then also the Medicaid funds to help support that as well. And then the MOU that we have currently in place, I think the deadline or the end date on that is in June, and so we want to take a look at that before that time frame.
Okay, are there any questions on any of those
Do you want a
points? I don't think we need a motion. I think that it's just here for information, so they have an idea of what we want and give them some input, and then they'll go back and work on it and bring some things back. Elisa?
I don't have any problem with the course of action you're taking so far with recommendations, but with an increase in this, there's going to be. I really want you to look at the data collection that's happening, because at the federal level, things have changed over the last 10 years, and one of the things that's changed is that when medical services are provided in a school, students are no longer protected under HIPAA. They're protected under PURPO, which is not as robust as HIPAA. And so I have a lot of concerns over that. And so anyways, I just would like us to look at, as you're going through this, to make sure that's going to be something that at least I'm concerned about.
Thank you, Lisa. Anybody else? Yeah, Lillian, go ahead.
And I appreciate that. We do want to make sure that our students are protected, and tied to that, our schools also need to look at what we call PURPO, which is even a little bit more stricter than FERPA. So just to kind of be mindful of that as well. So thank you. It's the yes, yeah. It's kind of like it's the Utah FERPA. It's
I have
yeah.
I don't usually hear it called that, but I think that's what you mean.
Okay, is there anything else before we let all these guys go? All right, thank you so much for coming. We appreciate your input. Presentations. All right, let's go to R277491, School Community Council Principal Responsibilities Amendments, and I believe this is Paula. Hi, Paula. Ben, you wrote this as well? Yep. Yep, you're on the hot seat again.
You might as well
That's-
just stay up there the rest of the meeting.
Okay. All right, Ben, will you introduce us to the rule and have,
So this is just the rule on school community council responsibilities for principals. The Trust Land Advisory Committee has some recommendations for some small amendments to this rule, and so that's what we've got before you. I'd probably defer to Paula to explain those.
okay, Paula?
Is this on?
No, you need to push the button.
Okay. This actually came
Paula, can you
from.
introduce yourself
Oh,
first?
sorry.
And-
Paula Plant. I'm the interim director for the School Children's Trust section.
Thank you.
This actually came from the PTA convention that was held last spring. There were some parents who indicated in a training that though it was their responsibility to approve and send forward to the local school board a school improvement plan every year, they were unable to find copies of it. And so they said, can we take this to the Trust Advisory Committee? We put it on the agenda and had a discussion, and this was after a couple of meetings. Actually, I thought it was going to be simpler than this, and it turned out that's probably important for you to know that part of the reason parents were not able to find it is it's actually turned out that some schools and districts use the school improvement plan and the school land trust plan as the same plan. So parents were preparing it and improving it all along. They just didn't know that they
I didn't
were.
realize that.
So that's all this is just it just creates another item that principals post on their website. So they would post either a link to the school improvement plan or a copy of the school improvement plan. And in the event that they're both the same, then they would explain that. Now, I know that there was a question, and I had Ben help me post this other document. There was a question about some of the other posting items that were currently in the rule. So there it is. So this is a document that we use with school community councils and principals to let them know what is required to be posted on websites to make sure that the public and their parents know who the council is, know what the council is doing. And the notice that's in the rule in 2A is not an election notice. There's supposed to just be a notice on the website always that explains to parents they have an opportunity to serve on councils and what it is that their councils do. Actually, the law does not require notice of the election on the website. If they want to do that, they can, but it's up to the council to make notice to parents in the best way that parents will receive the notice. That making sense? Mm-hmm. And some schools do it in many different ways. Some don't do it on the website at all. Some do noticing in other ways.
Okay, thank you. I don't have any public comment on this. Board members, do you have any questions, concerns? If not, we can make a motion.
Don't you move?
John?
I move that we pass this amendment to R277-451. Is that right?
491.
As proposed, and we send it to the board on this is passing on first reading and send it to the board for review on second reading.
Okay. So the motion is that we pass out our 277-491 on first reading and ask that the board approve it on second reading. All in favor?
Aye.
Any opposed? Okay, that passes unanimously. Thank you.
Thank you.
Mm-hmm. Sure, go ahead.
Okay. I think the next item we're on is 2.6.
Our 277-469.
And I just wanted to remind you all that a couple of months ago, this committee reviewed our 277-469, some issues that Alan Griffin and Ben brought to the committee from our Instructional Materials Commission, some issues that they had raised to their attention related to the depository requirements in 469. one of the motion that you all took at the time was for me to meet with superintendents and get some feedback from them about whether the depository was helpful to them or not. Because if you remember, we talked about how the statute doesn't explicitly require depository, but our board rule does. And whether or not districts and charters feel that the depository is helpful to them. The unanimous position, in fact, the superintendents took a vote to unanimously support the fact that they support having a depository, and they would like the practice to continue. So I wanted to give you that feedback that we did reach out. I also heard from a charter school association that they also feel the depository is helpful for charter schools too. So it's not just districts that support the concept of a depository.
Okay. Thank you, Angie. All right, Ben, do you want to go ahead and?
Yeah, so what we've done then is the primary substantive changes to this rule are in what is now 277-469-10 that starts on line 364. We've done.
Is this revision 1 or?
I've got revision 1 pulled up, and I'm going to explain that.
Okay.
We've done a number of stylistic changes here and moved some things around. But if you may recall that we got a letter from Mountain States Depository with a little bit of concern about the amount of books that a publisher should keep on hand in the depository. Revision 1 has a little bit of a change to possibly address that, and you may consider this language or something else. But the language in blue there is what we've kind of set forth as a possible.
Let's see, line 179.
So
Sorry.
the revision 1 would make the requirement that they have a classroom set of at least 30 books and tangible adopted materials or such greater amount as required by a depository based on anticipated need. So if a depository anticipates that they're going to need more based on the orders they're getting or the numbers they're expecting, they could require that of the publisher before they certify things to the board under the next subsection B. So we have suggested that as a possible change if the board wants to go that route to address the concern. And Mountain States, I'm sure, can speak as to whether they think that addresses their need, but that's one possibility. Alan, do you have anything you want to add about the rule before they ask questions?
No,
Introduce yourself.
Alan Griffin, Curriculum Content Specialist, Utah State Board of Education. My only concern at all about this revision here is how the anticipated need would be determined. I think it would be important to look at that. We thought about perhaps having information about historical records as to what has been required in the past, or orders from the school, if that was the anticipated need. I think that would need to be clarified, but I think that's, I like the change. I think it meets the needs that we've talked about. Were there questions about other parts of the document?
Are there any other questions before we go to public comment?
Questions or comments? Do you want?
Questions, just questions for them to clarify before we.
Well, maybe this is a good question for you. I'm looking at the same section, Section 10, how it's been amended slightly. And to me, from what I've heard from the folks at the depository, the experts, who I largely believe, their language, this language deals with the greater than aspect of materials that the depository would have on hand, but it doesn't deal with the possibility that fewer materials might be necessary or might be advisable or helpful. So I'm just wondering, and then Angie, just our excuses for our side conversation was that she'd heard from somebody from sources that a hard number was preferable. So I'm wrestling with this hard number, but it only deals with half the issue, and then the amendment that was recommended to me that deals with both fewer materials than 30 and greater materials than 30, and wondering if you have any kind of recommendation about that, Alan, if that's not too convoluted of a question.
The number 30 was somewhat arbitrary in the respect that we thought a classroom set was about what was necessary. But hearing that, I've had some publishers come to me, mainly local publishers, people who publish things locally, and suggested to me that the number 14 which is what we require them to send to us for review, was a large number for a local publisher. So I think your point is well taken. I'm not sure 30 is the appropriate number. It might be 5 would be enough, to help those lower end publishers.
I think good. And if I can follow up, Linda.
Go ahead.
And mostly I want this to be cost effective. I love books. I'm in favor of books in the schools. I can't say that enough, but I want this to be as cost effective as possible for both publishers and the purchasers. So I know we're looking for this. I think I'll propose this amendment that was proposed to me to replace that language when we have time, now that you've clarified that. Thank you.
I would add, if I may, that we're getting about 40% now of materials in digital format. Right. And in digital format, of course, it avoids most of this rule because there's no need for depository. So cost effective, we are getting many materials in digital.
And the balance is probably what we're aiming for.
Thank you, Ellen. All right. Michael, would you like to come up and make comment? Okay, could you introduce yourself for our audience in the vast world out there?
My name is Michael Syndergaard. I'm the General Manager of Mountain State School Book Depository in Clearfield. Thank you very much for the opportunity to address the board. As I look at the proposed changes, I think that meets the needs of the schools and school districts, LEAs, all of the charter schools. We just wanted to be responsive to the publishers because in some cases, as Alan was saying, 30 is too many books. The need for the number of books on deposit varies greatly, not only between LEAs, but the time of year. In June, we need much more material in our facility than we need in December because most of the school districts have purchased the materials that they're going to purchase. They need just to have a few books, and we want to be cost effective to the publishers and responsive to them, as well as make sure we have enough material on quantity. And so I think if they took out at least and just shall have a classroom set of 30 books and tangible materials or such greater amount, it may give a little bit more flexibility. I don't know that makes a huge difference.
Would it be appropriate to put or such other amount?
Or such other amount, yeah.
Yeah, that would fix it.
And I think that would meet the needs of both the publishers and the LEAs because we just want to be responsive and whatever other depositories that we've worked with, if they were in that situation, they just want to make sure that everybody's happy. The only other proposed change that we have is in section 4, which is on page 2 of the proposed changes. And this is very, very minor, but it's just for the sake of uniformity. It says depository means a business dedicated to storing and distributing resources or materials in sufficient quantities, and that's where we got the verbiage for our proposed amendment. So we just took it from 4. To ensure rapid and efficient delivery to patrons. Patrons is the only place in this entire document where that word appears. It's LEA schools or school districts. And so for the sake of clarity and uniformity, we proposed that be changed. Again, it's a minor change, but we think it makes it more clear to everybody involved what that means.
Okay. Lisa.
So the proposed amendment that you mailed us is different than this proposed amendment, and you're saying that you're okay with this wording as written, or would you?
Ben, can you walk us through?
Well,
what
I
you
mean,
just
I
said
understand.
That everybody said okay.
So I think.
No, I understand that he said that there was some minor changes, but overall.
for
I think
my-
the way it would
for me,
read,
let's see.
that would satisfy him, as I understood it, is if we put a classroom set of 30 books, striking out least, and tangible adopted materials or such other amount instead of greater amount as required by a depository.
Yes.
Okay.
So that could be
Just
greater or
the other
lesser,
one.
just depending on.
Gotcha.
Right.
But the default would be 30.
Okay, thank you.
So my question is, if we're making it so that they can do lesser or more, what's the purpose of the 30? Could it be the 14 or whatever they're already sending in for review?
Or could we have the language that they had suggested?
We can do that as well.
Or is 30
Angie,
just
go ahead.
guidance that's kind of.
Sorry, Angie?
I think, and Michael or Ben might be able, and Alan might be able to answer this question, but part of the reason why this issue even came to your attention is because there was some dispute about whether or not the depository itself had the authority to dictate the number of books that needed to be in the depository. And that language is probably fine, and it will actually give the depository that authority. I think sometimes just to set some number that people can refer to, if there's just dispute, it's like, well, you have to have at least whatever number, and I don't know, what do you all think the value of that is? I just remember my recollection is there were some disputes about whether the board or the depository or anybody could tell a publisher that they had to have something in deposit. And by just making the language broad like that, we are giving the depository quite a bit of authority. So,
And I don't think so much it's the depository. I think it keeps the depository safe as well, because if they say to one publisher, you've got to have 3 or 4 books, and another publisher, they feel like they need to have 30, and then the first one comes back and said, hey, wait, so I think it kind of gives them some guidelines better that will make things better for them as well.
Just if I can just point out, like Alan said, the number 30 was kind of an arbitrary number, but and Alan can correct me if I'm wrong, but we threw out a number because when the rule didn't have a number before, it was leading publishers to believe, well, they could just put one book on depository or just like a really nominal low number that clearly wouldn't meet the needs if there was an order for it, and so they wanted some number in place that could be kind of a initial mark, but. That's why we proposed something a little different from what Mountain States had put in their letter, was because we kind of felt that it would be good to have a kind of a baseline number with some flexibility, just because otherwise it might give publishers the impression that they could lowball what was needed.
Okay.
I just have a question. So the rule then would read, districts shall have a classroom set of 30?
The
the publisher, right.
No, she's right. She'll have a classroom set of 30.
Shall have a classroom set of 30. It's still, even though you took out at least, you have the shall have. So we're still saying that.
But then it's
or such other amount.
Or such
other number.
Other amounts.
That would be the suggestion to change.
We may want to say lesser or greater, because reading it, I'm thinking or other amounts. Your minimum is going to be 30.
Or other such.
I think it has the same significance legally, but we could write it
other or lesser, or greater or lesser.
Okay. Elisa?
I would like to propose an amendment to change that number 30 to a lower number, and the reason being is that, yes, there's a lot of traditional classrooms. Unfortunately, there are 30, but there are a lot of places, and charters included, that have smaller classrooms. And so to have a minimum, I know it's not minimum because of the other language, but it could become a problem. And I would prefer that we put maybe an ideal classroom size in that number. And that way it helps protect. And I'm also thinking of my very rural districts that have 200 students total. And
You say 14.
I don't know, that seems like a very small classroom size.
Well, it also feels kind of arbitrary. At least experts are giving us 30.
Right. Well, but they said that was arbitrary. So the reason why I would go with the 14 was only because that's what the standard was for the review. So they're already sending in that many anyway.
Alan, do you have a suggestion for an alternate number? Since you work with publishers so much.
I personally probably think 10 would be adequate. I came up with a number of 30 because in my mind I was thinking maybe there would be one school that needed a textbook, and they needed it for a whole class immediately, as fast as they could get it. And so it would be nice to have that whole classroom set there at the depository. But if we're specifying now based on some anticipated need, that there is a greater or lesser amount, I suspect that the depository can cover that. But again, I'm not married to the 30 at all. I just want to make sure that there's enough that any given classroom that needs textbooks immediately can get them.
Okay. Michael, would you feel comfortable with 10?
Yeah, absolutely.
Or do you think there should be?
We just, the way we wrote the wording is we just wanted to leave as much control with the local LEAs as possible and not leave it up to the publisher to decide how many books they're on deposit, not leave it up to the depository to decide. The LEAs get to really decide the quantity amounts that they need, and both the publisher and the depository work very closely with the LEAs to decide. So we're fine with that language. We just want to make sure that we want to have enough material to supply the needs and that the LEAs get to choose how much material is available to them from the source that they choose to have it available.
Okay. Carol?
Let me make an amendment to this then, and then I've got a couple of other minor grammatical things. Is that okay?
Go ahead.
So then this section would read, delete the at least.
So are you making a motion?
Right. I move that this section in R277469-10 paren 2A reads, a school district shall have a set of 10 books and tangible adopted materials or such greater or lesser amount.
I would say or such other amount.
You're okay now with other, okay? Or
Are you okay with
I am, yeah. Or such other amount as required by a depository based on estimated need. So,
Okay,
you want me to change that from anticipated to estimated?
I maybe misread that. Based on, is it anticipated? No, that's fine. Anticipated. I just misread.
Okay, so the motion is that.
Tired.
Do you want the change to the definition that he's proposing?
Let's do one motion at a time, guys.
I agree. Okay, then I've got some other. You want me to
Okay, let's do. So the motion is that we change, starting with line 378, right? Mm-hmm. Schools or school districts shall have a set of 10. You want a classroom set or just a set?
A set. I think I said set too.
Okay. Schools or school districts shall have a set of 10 books and tangible adopted materials or such other amount as required by a depository based on anticipated need.
Right.
Okay.
Does that work?
All right. All in favor?
Oh, wait.
Comment first. Okay.
Well, I just want to make sure, one of my biggest concerns about this is, yes, I was sitting in the meeting when the superintendents said it, and I appreciate that an association for charters said it, but I still want to make sure that we're giving the flexibility if for some reason a district decides not to, that this doesn't inhibit that at all.
So later down in the rule, you'll see that they can.
The statute.
Line 386, notwithstanding the provisions of subsection 2, publisher may sell instructional materials directly or through other means.
Thank you. I just wanted to make sure. Thank you.
Okay. Any other comments before the vote? Okay. All in favor?
Aye.
Aye. Any opposed? Okay. That passes unanimously. And now we're back to, Carol had another.
The motion on the, in section 4, I didn't catch the.
The definition.
There was a recommendation in the definitions on line 43 to change patrons to LEAs.
Oh, yes. Means a business dedicated to strong distributing resources and efficient delivery. Yes, it doesn't really go to patrons. It goes to LEAs, which covers everybody. So, yes, I would move on line 43 to strike patrons and add LEAs.
Okay, so the motion is on line 43.
And Linda, I have a couple of others that are just really minor, and then we can not have to do them all. And we can do them all together. Is that okay?
I think we'll just do them one at a time. I think they'll be fast enough. At least we'll do this one, and then we'll do, maybe we can do your two grammatical ones at the same time.
Question. Should we change it to LEAs or should we change it to Utah schools and school districts?
That
Or
would be
will LEAs?
encompassed in the LEAs.
So
Okay,
that would
let's,
all,
let's,
yeah, just wanted to
let
make
me read the motion first, then we can have discussion, okay? So it would be materials in sufficient quantities to ensure rapid and efficient delivery to LEAs. That's the motion, that we change patrons to LEAs. So is there any discussion?
Word sneaked.
No more discussion. All in favor?
Aye.
Aye. Any opposed? Okay, Carol, you had a couple of grammatical things you said.
On line 196, you've got an LEA shall provide timely notice to all publishers with whom it contracts, or the LEA contracts, as opposed to they. Hate that. They, the universal pronoun. I had to add that aside. So that should be an it or.
Typos, do
And then the other one is right below that on line 199. I shall include a copy of R277-469 striking this. I don't need why we need to say this.
That's the way the stylistic manual would.
Oh, really? That's weird. Okay, then I'll live with that. But the pronoun change is not stylistic.
Okay, so is that your motion?
Yes.
So the motion is, if I understand it, that we will change line 196 to an LEA shall provide timely notice to all publishers with whom it contracts.
Or the LEA
Do you want to put
contracts.
The LEA contracts.
And you've got to make contracts.
Okay, so we'll start over there, Sybil. Okay, an LEA, this is line 196, an LEA shall provide timely notice to all publishers with whom the LEA contracts for instructional materials. Okay. So are there any other questions on that?
Sorry to be a little tedious, but I have a question on line 227, which...
Let's vote on this one since we have the motion. And
all right.
Okay, all in favor?
Aye.
Aye. Any opposed? Okay, that passes unanimously. Okay.
Line 227, following its evaluation of a submitted item, the commission may recommend, and is that your sense of the rule writing manual that it can't say that it leaves that open-ended, or is it required to recommend something?
Do they have to require?
It's in statute.
It would be one of those, so yeah, I can see that would be shall.
So I think that should be a shall.
Okay. Anything else, Carol? Before
No, I can only do one at a time, so.
No, I
let's just
said
do
we
that.
could do those other two together.
Oh. Let's just do that one. That's
ready
all I
to
have.
do that one?
No, that's all I have.
Okay. So, so line 227, following its evaluate, the motion is line 227, that we change it to following its evaluation of a submitted item, the commission shall recommend. Okay, are there any questions on that? Okay. All in favor?
Aye.
Aye. Any opposed? Okay, that passes unanimously. Okay, I think is that it? Okay, thank you all.
Did you pass the rule out with those changes?
Oh, did we pass the rule out? I don't think we did that.
We did the amendments. I think we still need.
We did the amendments, so we need to pass the amended rule out.
Nope.
Sorry. Thank you, Ben. Okay, Carol?
I move that we pass out R277-469 as amended on first reading to the full board for its consideration on second reading.
Are you continuing it too?
And continuing the rule as amended.
Okay. All right, so the motion is that we pass out R277-469 on first reading, continue on continuation as amended to the full board. All in favor?
Aye.
Any opposed? Okay. So that is, thank you. That is unanimous. All right, so we'll go to the next one here. R277-515, Utah Educator Professional Standards Amendment and Continuation.
Okay, so this is a follow-up to the discussion item brought to the committee last month. This rule needs to be continued by November 15th, but we've also proposed a few changes to the rule, and so I can go through those with the committee if you'd like me to.
Please.
As far as definitions, we've proposed amendments to a couple of definitions. First, on line 53 is the concept of conviction, clarifying that that includes the way that basically the final disposition of a criminal case, including finding of guilt by a judge or a jury, and a guilty or no contest plea, or a plea in abeyance. This basically puts the rule on in the same footing as we have it in the presumptions and the other UPAC rules would be closer to the same definition. The other definition that we changed involved a couple other definitions. We've put a definition of pornographic or indecent material to mirror what's in the statute to provide a clear definition of what that would comprise. That's what's used for the statute on possession of pornographic or indecent material on school property. And then we have a new definition for under the influence of alcohol or an illegal drug. What we've done is we've taken the methods of proof that are used for proving a DUI and kind of changed the language up a little bit to use that in the school setting. Basically, it would be a 0.08 threshold for being under the influence or under the influence to such a degree that it would render the person incapable of effectively working in a public school is how we've set that up. We've also added language throughout to show that the discipline that would be recommended would be done in accordance with R 277-215. That's the presumptions rule. And then we've gone through this as far as the under the influence of alcohol on line 142. You can see that we've changed it from may not attend school or school-related capacity activity in an assigned supervisory to employment-related capacity. This was based on the feeling that a teacher shouldn't be in a classroom under the influence, not just if they're in a supervisor or administrative capacity. We've added on line 187 a provision just clarifying the reporting requirements, bringing in the reporting requirement from R 277-516, mirroring that in that rule to make that part of the educator standards. And then the other big substantive change that we have is on lines 265 through 268, where we've tried to clarify a few things with regards to the pornographic or indecent material rules, clarifying the language there, and then also adding a specific provision that they can't knowingly use, view, create, distribute, or store pornographic or indecent material involving children. I think that goes without saying, but we wanted that clarified specifically to tie it to our presumptions rule as well as to address other issues that have come up with regards to that particular concept in past cases. So I think that's primarily, oh, and then there was one other change that we did on line 313, which is that it would be a violation of the educator standards if an educator doesn't follow a school or administrative policy procedure or document a directive. We had proposed putting that directive, and Board Member Lear suggested that be clarified, that would need to be documented, and so that's the language we've proposed in that regard.
Okay, thank you, Ben. Are there any questions for Ben before we go to public comment? Okay, Tracy.
I have a question.
Okay.
I just, and this is kind of a general question, but it is specific to the rule. I feel like we spend a lot of time amending these rules, increasing the punishment, broadening the punishment. I'm just wondering how many times we work on the front end of the problem, and how many training, how much have you or your staff, I mean, could you tell me a number of times, how many times you've provided training to LEAs?
Nicole, do you want to come up here?
I don't.
We go
one
out.
time.
We go out and offer
25
training whenever anybody asks.
So
us to.
what's that been in the last 2 months?
Well, I usually delegate that to my attorneys. That's why I'm suggesting that they come up.
Stephen,
and answer
Nicole,
that
come on up.
This is Nicole Ferguson and Steve Oler. They're the attorneys on my staff that investigate cases.
Great to meet you both.
That was on. Morning. Nicole Ferguson, and I think I've done one in the last 2 months, I'd say. Since school started, and I have another one actually in the next 2 weeks.
I've also done one in the last 2 months.
And so you only do it upon request?
Generally. The last one I did was the entire Tooele School District when they had their orientation for the district. I went and I talked to everybody there.
For an hour?
My presentation was an hour, yeah.
I would like to say generally that I wish we would spend exactly as much time on training as we spend discussing the prohibitions and the increasing and broadening the punishment that goes into these rules.
Julie noted. Thank you.
Thanks for those answers.
I had a question about that also.
Oh, I'm
sorry. I'm just curious how are you notifying districts and other personnel that the training's available, or do they just have to kind of know that?
So I've taken opportunity to tell the HR directors when I've had the opportunity to present to them that we are available to do that. We haven't made great lengths, gone to great strides to tell them, this is available, but we could take any steps that the board deemed appropriate to advertise our services, because we're more than happy to do that. I go out and make those trainings like they do it occasionally as well. But we're happy to advertise that in any manner the board deems appropriate.
Okay, thank you.
All right, thank you. All right, Tracy, did you have a comment?
Tracy Watson, Utah Education Association. Yeah, on the issue of training, I've been trying to do some training for our members as well.
UEA does training as well, right?
Well, we haven't formalized it, but because really the members that come to me that have an allegation of misconduct, they don't know the educator standards. And so, and I get that they're responsible to, right? And I get that the districts do it, but there's so much that these teachers are given at orientation, new teacher orientation, or just yearly orientation, and most of it is check the box, right? But people don't really come up against the professional standards until there's been an allegation that they violated one of them. I mean, that's just how it is in practice, right? And most teachers sort of know by instinct what's good professional practice, right? But we need a little bit more than that, right? Because that's sort of how we get into the complications. But on this rule, I have a couple of comments. First when we go to adding the definition of conviction, I mean, it's sort of like anytime you open a rule, I would like this committee to think about whether or not a conviction should include a plea in abeyance. Because for licensed disciplinary purposes, if you enter into a plea in abeyance, it's a conviction. And the difference is many people enter into a plea in abeyance because the plea in abeyance, first of all, it costs money to go to trial, a lot of money. And second of all, the plea in abeyance goes away. So if your plea in abeyance is a year, 18 months for a Class B assault, it goes away. And it goes away as a dismissal. So 18 months later, you have no criminal charges. You have no criminal convictions. But with licensing, you have licensed discipline based on a conviction. So if you want to include plea in abeyances, first I ask, should they be included? And second, if they should be included, should that educator have another process where they can come after the abeyance period, since it was based on the plea in abeyance, can they come back to the board sooner after the abeyance period has run out, when they no longer have a conviction? Because they were disciplined based on a conviction, but when that conviction goes away, should they have a way to come back? That's something because what happens is every time we change 515, it looks like we're just changing it a little bit. Just add this line, just change this word, but we're not. We're changing the process, and we're changing the totality of the process. And we're slowly but definitely increasing the focus on punishment and without any rehabilitative component.
Do you have any other specific concerns?
I do. So also generally and throughout the rule, the changes are trying to marry the educator standards to the rebuttable license disciplinary presumptions. But it's not just UPAC or the state board using these educator standards. The districts are using these educator standards as well. But the rebuttable presumptions are limited to the board and to UPAC. They're not imposed by the district. So you're setting up a system which is, you're trying to marry these systems, and anybody that's disciplined under 515 must report that. The district must report that to licensing. And then licensing is going to look at the same offense, the same set of facts, and then also discipline for licensing. Well, now what you're doing is potentially creating competing processes. Okay? Because you're putting it in the rule that now the districts are also going to be having to look at the rebuttable presumptions. But the rebuttable presumptions don't really apply to district discipline. And now you're potentially setting up a system of double jeopardy. You have two agencies looking at the same standards, the same rebuttable presumptions, and potentially coming up with different disciplinary actions. When you do that, like just on October 5th, and I'm sure that Brian Quisenberry and Ben are on this, but there was a case issued in Burgess v. Department of Corrections and Career Service Review Office. And the Court of Appeals took some time, beginning at paragraph 35, to go through when the Court of Appeals looks at assessing employee misconduct and whether or not the misconduct warrants the certain sanctions, they look at whether or not the sanction is proportional to the discipline and consistent with the past practice. If you're seeing letters of reprimand at the district level and suspensions at the license level, you're creating competing systems and you're creating a proportionality argument. So it looks like it's just simple, let's just marry this to the presumptions, but it's really not. When you marry this to the presumptions, are you requiring school districts to also, when they discipline for violation of the educator standards, are they having to look at that as well? Specifically, if you go to line 100, so the definition 16A, under the influence of alcohol or an illegal drug, means that a person, line 101, is under the influence of alcohol and illegal drug or the combined influence of alcohol and drugs. Now we don't have illegal drug anymore, we have drugs. So I'm not sure if that does also include prescription drugs or not. So you may just want to look at that because it isn't clear. We have the word illegal twice preceding the word drug, but then we just have alcohol and drugs. If you go to line 143, we did talk about this at last month's, and it used to be the supervisory capacity, and now it's an employment-related capacity. That is a much broader standard. You are definitely changing the implementation and the practice of this rule, and I'm not sure based on what. I don't know why. It's not clear to me why. If a teacher is teaching a class, they're in a supervisory capacity. They're in charge of that class. So no teacher should be under the influence while teaching the class. But if the teacher is at a football game or the teacher is at a choir or a musical or a play, and the teacher didn't drive there, you're now making that teacher subject to employment discipline if they're there, because anytime a teacher's on campus, they're there in their employment-related capacity. They're there as a teacher. Everybody knows Mrs. Stallings, fifth grade teacher, is at the play. Do you want to broaden that standard to just employment-related? And if you do, that's fine. Just know that you're increasing punishment and you're increasing discipline. Is it necessary?
So my comment to Angie is that it says an assigned employment-related capacity. So presumably they would be there assigned. It's not like they're just showing up at the, to see a play or something like that. They would be assigned to be
We
there.
know that many of our teachers have students in the schools, in another school. So oftentimes they are acting as a parent.
But then they wouldn't be assigned.
They wouldn't be assigned, but that's going to be a really finite distinction. So it's sort of like, go ahead.
I just wonder if the reason why we've changed it from supervisory to employment related is because there was ambiguity about whether it's only for administrative level personnel versus, you make the point that somebody could argue that a supervisory means a teacher who's supervising students. Somebody else could make the argument that supervisory is only if the person actually supervises other employees. So that, I mean, in some ways, if they're assigned employment related, it does seem like that would get away from if the teacher went on their own volition to just sit in the audience but they weren't actually requested to or assigned
But even
to.
if you're in the supermarket, like I know this doesn't apply to the supermarket, right?
Yeah.
But even when the teacher's in the supermarket, she's the fifth grade teacher. There's my teacher. There's my teacher. There's my teacher. She's not assigned, but it gets more blurry when she's in the school.
Linda, in response to this back and forth, I think supervisory is beginning to be understood by educators, which I think is an important factor. And now you're switching the definition. Couldn't we remedy any ambiguity you see by defining supervisory as opposed to changing it to assigned employment related, which says in my mind almost exactly the same thing, but a little broader, just a little broader. And I think if we defined supervisory to include being in charge of a class or a group of students, or that would then that would improve that feeling about this rule. That's just, let me finish for a second, Linda. That's already coming to be understood by educators and not. Well, wait, we've got another term.
An example I would give why this is appropriate to change this to employment related would be a case that we had on the board agenda yesterday. It was an educator that had gone to a training where she was going to be trained, where she was well over the legal limit of alcohol. That wouldn't be in a supervisory capacity, but it's certainly not appropriate for an educator to be going to work in any capacity, employment-related capacity, when they're in excess of 0.08 or when they're above the legal limit or under the influence of illegal drugs. So I think that's an example of why this language would be appropriate. In a lot of circumstances where educators are teaching, yes, they could be argued to be in a supervisory capacity, but there would certainly be other defense attorneys that, unlike Tracy, would argue that, well, if they're teaching, they're not in a supervisory capacity. That's why we want to clarify that.
Okay, because she definitely was not in a supervisory capacity. She was just going for training. Okay,
correct.
Gotcha. Thank you. Okay, Tracy, anything else?
Right. So along those lines, absolutely, she's going for training, right? And the employer's paying for that training. And so if she's under the influence, it's likely that the employer's going to discipline her as well for that same offense. So the employer's going to discipline, and then the employer must report that to UPAC, and then UPAC's going to discipline. Same offense, same underlying factors. If the employer's discipline is less than or greater than UPAC's discipline, you have a proportionality argument. You have a proportionality problem. So is that something that you want to also discipline for? And you're limited to what's in 215. The employer is not limited to what's in 215. So you're creating a competing standard. It looks simple, but it's not.
Okay.
You have a past practice matrix for when they're in a supervisory capacity. So it's easy to defend your discipline because you look at how did we previously discipline. So if that discipline is different, no problem because you have a past practice matrix, right? But now you're abandoning the past practice matrix because you're changing it from supervisory to employment. So now you're creating a new matrix, and now you're creating a new proportionality argument. It's public comment. I just want you to see it's greater than just changing a word from supervisory to employment related.
Okay.
Okay? And also, last comment, when you go to the section beginning at line 295, professional educator responsibility for compliance with LEA policy. Remember, again, these are the same standards that the employer uses. And this is specific to the employer's policy. Why does UPAC want to discipline, again, for something the employer has already looked at and already taken an action? Again, that's sort of a double jeopardy. You're going to have the same facts, the same standards. But the employer's already taken its discipline, and this is where it's even more obvious because this is where it's for the employer's policy. So I think that sort of underscores the other general comments that I made. Do you want to sanction an employee's license because they didn't comply with an employer's written or documented directive when the employer's already disciplined for that? These aren't little changes, they're big changes.
question for Tracy.
Okay.
So then, for instance, to just asking if this is what you mean by an example, if an employer disciplines for insubordination, whereas licensing discipline has never been specific to insubordination, would that perhaps put the employee in jeopardy of licensing action for insubordination?
Yeah.
Ben?
Just point out that rule is broken out into two categories. There are certain violations of an employer's policy that shall result in licensing discipline. That's things like boundary violations and financial impropriety. And then in subsection 3A is things like insubordination, contract violations, things like that may result in licensing discipline, not shall. That would be the documented directive, grievances, things like that. So there are some things that are mandatory, and they were mandatory before. There are most of the things that are an employee's policy are more discretionary, and that's if the district feels it's appropriate to send it our way. That's when we look at those.
But it's not. It's no longer if the district feels it's appropriate. The rule requires the district to report.
Only if it's something that requires mandatory licensing discipline.
No.
No, that's not true in the reporting standard.
I can't find my button, but then I'm misunderstanding. Then it's not clear.
It's not in this.
And I try to read things to understand them well. But the way I read 515 is if the employer finds a violation of 515, that violation must be reported to UPAC.
Ben, can you point out the wording for us?
It's in a different rule, isn't it?
It's in 515 and 516. The way the rule is set forth is if there's a violation of the categories that require mandatory licensing discipline, yes, they are mandatory to report. There are also sections that are discretionary licensing discipline. Those are discretionary to the LEA to report if they think it rises to the level that UPAC should review it.
But like, for example, let's go to line 122.
So which one are you in now?
I'm in 515.
Line what?
With the copy that I got, line 122, it's in section 3, educator as role model of civic and societal responsibility. That's sort of the broadest category. And if you look at line 122 and 123, or subparagraph 3, failing to strictly adhere to subsection 4 shall result in license discipline in accordance with rule R277-215. So again, when you're adding that, and because this applies not just to UPAC, but it applies to the employer, are you requiring the employer now to use the rebuttable presumptions under R277-215?
Okay, Ben?
The employer doesn't give licensing discipline. Licensing discipline is done by the board after a UPAC investigation. This has nothing to do with how the district investigates this, what they do with the case. This is the licensing discipline, which is UPAC conducts an investigation and the board takes action.
But again, for the same offenses that the employer will be. And this is for the role model rule.
Okay, are there any other questions for Tracy before we have board discussion? Okay, thank you, Tracy.
Thank you.
Okay, questions for Ben or Brian? Or a motion?
I would really like to request, and I've done this before and I'll continue to do it every single time, I wish that this discussion could be had with Tracy, with anyone else who would like to be there to represent teachers. I know there are other attorneys who represent teachers periodically. I have to say this one more time, and again I'll continue to say this. I'm the only level 3 licensed teacher on the board. I do not want bad teachers in the profession. This is not about protecting bad guys or bad teachers. This is about fair processes when it so dramatically alters people's lives. It's about privacy in some cases for teachers this time, educators. So I would really like to have a more collaborative discussion with any attorneys, any people who'd like to be there, rather than proposing these rules where I feel like there is a subtle broadening of the discipline for licensing, when I don't even agree with, we have not re-examined those presumptions, those rebuttable presumptions. I don't agree with those. Those were considerably changed about 2 years ago with very little input from those who would be most affected. So I'm really resistant to any changes that tie in the rebuttable presumptions, that broaden the penalties for teachers, without a really fair and consistent airing of this, having this discussion. I just think it would be so much healthier. We can't, there aren't enough policemen otherwise if we don't have the profession agreeing that we want to improve.
I am going to thank you, Ben, for bringing these. I think that personally, as I read through this, that it clarifies a lot of things that needed to be clarified. So I appreciate Ben bringing this forward, and I'm okay with the changes. I think they're better. I think they clarify things for us. Unless there's something that Brian sees that he thinks is a concern, I don't have any concerns with the rule.
The only question on the reference to supervisory, was that referring to supervising children or supervising other coworkers or other?
Well, that's the question that we don't know the answer to from the rule.
It could be defined it could be put in the definitions, which is what my druthers are. But I think the whole thing needs more discussion before.
And it's fairly clear that when you go from supervisory to employment related, it's definitely broadening. And if that's the intent of the committee and the board, then that is, I would think, be appropriate.
Okay, thank you, Brian. All right. So I'm going to go ahead and make a motion that we pass R277-515 out to the full board on first reading.
That needs to be continued as well.
Oh, it needs to be continued as well. Okay. On continuation, first reading. Yes, Elisa.
I would like to define what supervisor means, because I agree that we can't just leave something arbitrary for.
Supervisory is taking out, being
so you
taken
struck
out.
it out. Okay, sorry, I just was confused because of that last comment.
Yeah, it's being taken out and put in employment related in there.
Line 142 and 43.
Let's see. Are there any questions?
I have one more point to your motion, Linda.
Okay.
We're going to have an administrative rules hearing on this. So would we not rather have the discussion prior to that hearing rather than have that kind of a more of a contentious kind of discussion? Could we not have a discussion on this before the rule is passed out rather than after?
So, okay, let's hold on just a second. Thank you for your comment. She's looking at 143, you see. Mm-hmm. Do you see that, Elisa, where a supervisory was crossed out and employment related put in? Yeah, go ahead.
Just to clarify, I think if you're trying to determine what the policy is that you're voting on right now, I think that Ben raised the policy call. Yesterday, you heard a case where the person was not in a supervisory position, but there was a blood alcohol level that was high. Do you want that to be included, or do you want to limit that if somebody is at the school, but they do have a high blood alcohol level, that's okay? And I think that's the difference between supervisory and employment related.
Right. I disagree with Angie. I think there are other ways that you could do that.
There are other ways, yes.
That wouldn't broaden it to all employment related. That you could say supervisory or assigned capacity or something that would. But my point is still, the bigger point is still there. We're moving to employment related with no discussion with those who are most affected.
Okay, Michelle.
So when I read this as employment related, I didn't read it as a teacher attending the football game because their son plays on the football team. I read it as a teacher that was specifically asked by the principal, you will be in attendance as to watch over the students or whatever, like they are specifically there as part of their employment ask, not there just watching a football or soccer game. Is that correct? Is that?
Yeah, it would be like if a teacher were asked to be the PA announcer for the game.
And Brian, is that how you read that, or is that how it? Okay.
Okay, Elisa.
I was just going to suggest if Carol has amendment she'd like to propose, that you should propose an amendment, and then we can think about it instead of just saying you don't like this or you do like this. If you propose an amendment, then it gives me something to think about
I don't have, in response to that,
Go
her
ahead.
question. In response to that, Elisa, I'm more concerned about the broadening generally without discussion. I don't have a specific, I don't want, if I were to propose amendments in the moment, I don't think it'd be very thoughtful. And I've even thought about them even before this. But for instance, I don't want to tie anything to those rebuttable presumptions until we re-examine the presumptions. I think that's precipitous. I think it is not, and I just don't think that making changes to rules by administrative rules hearing is the ideal way to do it when we know there are groups that have significant concerns.
Okay, Elisa?
I appreciate that. And I think one of the things that we can utilize right now with the change of our board schedule is that we now have some time between this vote and before it goes to the full board where we can have that dialogue where we get to hear from the public and from the entities that you're concerned might propose a hearing before we get to that vote. And so then that gives us the opportunity to hear that. But if we just sit on it, then it is limited to those that actually are sitting here in attendance, whereas if we were to move it, then you may have a broader public notice and a bigger discussion in general than I think that we can have by just holding it and only inviting specific parties to the table.
And just to clarify, I'm not suggesting just inviting specific parties to the table. In fact, that's exactly what I don't want to do. I want to make that invitation to anybody who would be concerned. If it's PTA, if it's school boards association people, I just have learned over the last few months where we've had more administrative hearings than I've ever seen in my life that that's not a productive way to make policy. So I would rather, in a month's time, it's okay. In this case, we've got 2 weeks plus, so it's not very much time.
I think it is helpful to know that Angie did pass the superintendents and they didn't have a concern with it.
I did, but I don't think that superintendents deal sometimes with their employment issues as specifically as do their HR people. But I also think there are others who might be interested. And Michelle made the very good point. Well, then propose amendments. And I could certainly do that before the board meeting, but I just don't think it's as productive as a collaboration, as a discussion and it doesn't have to be just certain invitees. But I think this is something that has a profound influence on a lot of us. And I want good teachers. We don't have enough policemen to make that so.
Okay, I'm going to call for the vote. All in favor? Aye. Any opposed?
No.
Okay, so the vote is 3 in favor and 1 opposed. Okay, thank you. All right, thanks, Ben. Thanks, Brian. Oh, board bylaws and board policy. And is Ben going to work on that one too?
Yes.
Okay, awesome.
So the section that we have in front of the committee this month is section 6. Which deals with the board member elections and then the responsibilities of board members. And I think the anticipation was that we would have a little bit of discussion today just with regards to how elections for board officers should be conducted in the future.
Can I just put something in here so you guys know where you are? We're in the bylaws, board bylaws, and just for your information, committee members, what Mark has asked is that we look at all 3 suggestions of how to do board elections. We recommend 1, but all 3 will go to the board so the board can see all 3 of them. Just so you're aware that that's kind of how that's going to work. So as Ben goes through them with us.
So what we've done is you have in board docs, you have 3 revisions of the board policy 2002 that spell out different options for how the board could change the election process. And the AGs have given us counsel that we need to change that process because the votes of each board member need to be recorded as to how they voted for board officers. And so we've presented 3 options here. Revision 1 is the first option.
Relevant to what you just said, the votes have to be recorded?
Yes.
Under the open
It has to be
meetings
an
law.
open.
Oh, okay. So they haven't been doing that. Thank you.
For the last 10 years, about.
We have not been doing that?
That's right.
No, not on board officers.
Yes.
Yeah, and it's not allowed. Okay.
Not okay.
So revision 1, the way we've drawn it up, is it would essentially be the same process as you're doing right now, except you'd write your name on the ballot. It would still be kind of anonymous until after the vote is over, if that's something that is a concern to members.
It wouldn't be kind of anonymous.
Well, during the process, yes. After the process, no. So that's why we would have the board members write their names on the ballot so that we could properly record that in the minutes as required by the open meetings law.
Can I ask a question about this one, Ben, if that's okay? As I was reading through here, I didn't see the specifics. I thought there were specifics as you do this many ballots, and when there's a third one, you take this person off.
That's already in the bylaws.
Oh, okay.
That's the same process as you have right now.
But we want it to change that.
You can change that if you want to change that. We've kind of spelled out a few basic options, and then you can take one and run with it.
Okay. Okay. All right.
So option 1 would be essentially what the board has been doing up until now.
Except
you write your name on the ballot.
Okay, and then it also says that we would decide on the number of vice chairs the month before.
That's correct. Angie, I should point that out. Angie asked me to put a couple things in each of these revisions. The first is, and that's spelled out in paragraphs 4 and 5, and that's that you would decide the month before how many vice chairs you wanted to have, and then also that the candidates wanting to run for either board chair or vice chair would submit their name in advance of the election day. And so I've put 7 days here. You could change that to whatever you thought that should be, but I was asked to include that policy option in each of these just in the draft. You can take or strike any of those.
So I have a question about that. So during the month before, so we vote for board leadership we voted in December, right?
Yeah, we can do it in January too, I think.
Whether or not we're going to have the amount of vice chairs would be determined in November, but in an election year, I really feel like those that have been newly elected should have a say in how many vice chairs they would like on their board.
That's something you'd have to consider as far as this is a policy option but you raise a good concern there. How do you do that during
keeping it in December,
which is every other year.
Just letting them decide then in December, striking that out. I mean, I can.
Well, the reason for it, I think, is that I think Angie. I've had so many discussions. I've had discussions with Lorraine about this, with Angie. I was the one that asked board leadership to bring this forward because so many people have asked that we change it, and I knew that now is the time to change it if we're going to change it. I expect this to be a big board discussion, but. The thing is, I think it's kind of chaotic at the time. We have people jumping into the election, people, at the last minute, and I think that we're trying to decide on vice chairs. So if we could have all of that decided up front, have our slates all done so we can talk to the people that we know are running, then we can make our decisions before we come, before it becomes so chaotic. I think that would be
I can
better.
See that. I didn't feel it was very chaotic, though. I felt like I had a voice, at least, in deciding whether I wanted 1, 2, or 3 vice chairs as a newly elected board member. And if that decision had been made for me by the person who was on the board prior to me,
I think that's something we need to
then
address.
I would not be happy about that because my voice wouldn't then be heard as an elected official.
Why do we need to do it the month before?
Because then the candidates can declare their candidacy.
Then you know that there's 3 vice chairs.
Sorry, I'm looking at preferential voting because that's something that I would like.
So Ben, why don't you give us the overview of all 3 of them, and then we can talk about it a little bit more.
Certainly. So revision 2 would be what's called ranked voting, and this is something that's been picking up steam. A lot of people are recommending using this type of voting for a lot of different elections across the nation. But the way ranked voting would work is essentially if you had, say you have 4 people running for an office, you would get a ballot that tells you to rank each of those people 1, 2, 3, and 4, and then they would count up the number of first place votes for each person. Then the person that takes 4th place, they'd be dropped off if nobody gets the 8-member majority, and then you'd recount you'd recount the ballots and you would give the vote to the highest ranked person that hadn't been eliminated. So that with ranked voting, someone drops off the ballot each round until you have somebody that receives a quorum or 8 members of the board, and that's done by ranking them in the first ballot. That saves time in that you don't have to conduct a new ballot each time because people have already ranked people in the preference they like, and you can go through and just count up, and the tallying goes rather quickly because you don't have to have a new vote each round.
Okay. So that's the second option.
So with that option and the third option, we would need the bylaws change because that would take off the voting by rounds.
Let's just do it. Change the bylaws later.
The third option would be probably the simplest matter. That would just be to conduct a voice vote, and so you'd say how many for Chair Huntsman, how many for whoever the candidates are, and you would just do a voice vote that would be recorded as you conduct votes on most of the items that come before the board. So that would just be a separate voice vote for each position, in accordance done by, and that would be how we would do it.
Okay. Thought was, Ben, and I don't see this here, and maybe we could tweak the first one a little bit because I don't think anybody really liked the way that worked, was that instead of having all those separate ballots, that we just do it like they do in elections. So you have the first ballot, say there's 5 people on it, and you take the top 2. If nobody gets it, you take the top 2 and have another. Or because we were just taking off 1 and then doing the next 4 and then taking off another 1 and doing the next ones. And that's why it took so long, I think. But I wonder if it would be just as easy. I wonder if it would have the same effect if we had just do it like we do it on regular elections, right? And they have like a primary where you have everybody on the ballot. You take everybody votes for 1. You take the top 2, and then they go on to the final ballot or whatever.
That would just be a simple change to the bylaws and using revision 1.
Okay, Elisa.
The reason why I prefer preferential voting is because I may have changed my vote if I knew that so-and-so wasn't going to be in the top whatever. And so by being able to rank them in order of my preference, then when if nobody got the majority, then they move off and you only have to vote 1 time.
Yeah. Right.
Anyways.
So you like option 2.
Yeah. Well, I mean, I want to study the way it's written and make sure that there's nothing in there that anyways.
Yeah, my concern about voting does anybody like option 3 where you just raise your hand?
No.
I like it. I do.
Okay. My concern on that one is sitting in board meetings and seeing people look around, see who everybody else is voting for, and then they raise their hand, right?
But it's a public
So
process.
The other one is still public because it will be released after, but at least it keeps.
It's not as transparent, though, to use that favorite word.
Yes, but then others' votes aren't swayed.
That's the nature of democracy, I think.
Well, we're a republic.
Okay, so do we have any
constitutional republic?
Okay, let's look at number 2 then, since that seems to be what you guys favor here. So we can look at number 2 in more detail, should we? Okay, revision 2. All right. All right.
The audience wants to hear this debate.
They're really excited about it.
Happy. Mob rule versus.
Okay. So as we go down, number 4, during the board meeting the month prior to elections, we could, if elections were held in November or December, though, everybody would still be elected by November, and they could meet.
But not by November 4th.
No, because it's November 8th.
November
it depends
8th
when the board meeting was.
Yep, Ben.
You've got, even if November board meeting was later on in the month, you still have time. It requires time to certify the elections. I think it's late November.
That's true.
You may actually have the results for each election if something was close.
Okay, so how could we do that, Angie? That was your suggestion. And I think it's a great suggestion so that we know.
You're talking about the voting.
Yeah. So let's see. The month prior to elections.
I'm trying to think of a way
I think there's a decent argument that the board members are not sworn in, and I don't know that it's appropriate for them to be voting for anything until they're sworn in, as inconvenient as that is.
Lorraine, you want to come up? Lorraine, come up.
I don't know if anybody can hear what's being said there, but
Lorraine doesn't like to come up, but come on up, Lorraine, because she's gone through lots of these, and she's discussed this with me as well. And they used to do it where they didn't just nominate from the floor, right? So
Right.
and so that shouldn't be a problem. It's just letting everybody know by a week before or whatever that you want to be. You could say that you just want to be in leadership and we put in each one of them.
Right, and you can say from the floor too, right?
No.
Right now you can.
Well,
the way the
but
board
this would,
policies
this
I'd
would,
like to keep it that way
this
too.
would eliminate it. Why would you like to keep it that way?
Like I said, when those that get voted in November, there's a lot to take in, and you've got to study. And it was nice to have that amount of time to study to be able to decide whether or not I even wanted to run. I decided not to, but I don't.
If you have a week to study the candidates.
I just know of some that said, I didn't feel like I should run until now. And so, and to nominate on the floor, how hard is it to add their name?
I think it's just difficult as a board member to get to know people who pop up at the last minute and say, I want to run. I like
we
to
were all
have the
talking
chance
to
to
each
call
other
them on the
before
phone
then.
and talk to them and stuff like that. So I'd like to know a little in advance if people want to run. Just my opinion. Elisa?
Right, and there's always strategy behind things, and so I think that that it would be appropriate to allow both options, because some people will want to do lobbying ahead of time because that's what this ultimately is, or have conversations, answer questions, talk to people, and other people may want to just pop up on the floor. And I think that should be allowable. Or maybe someone wants to nominate someone that doesn't really necessarily want to put their name in, but they may be willing to do that if someone were to ask. And so I would like to see the availability for both options, because I appreciate those that want to put their name in and be able to, like you. I mean, I spoke with you on the phone, I spoke with Chair Huntsman on the phone, and I did have those conversations. But I also, if someone were to nominate someone on the floor, then I think that they should be also able to run.
You do have the problem of, as Ben mentioned, some elections not being close, so they'll have to be certified. So if you didn't allow people to be nominated on the floor, you wouldn't allow those close election winners to participate, which I don't.
How did it work before, Lorraine?
Well, there haven't been close elections.
No.
Well, there have been.
There have
actually.
been.
Well,
Yeah, we've had a
they
couple
just
that have been up to that minute almost.
We were allowed to nominate on the floor,
Right.
and
This last couple of years you've been
last
allowed
couple of
to.
years, but
Yeah.
before that, I'm
Before
wondering,
that,
before that,
I
how
don't
did it
think
work?
there was any problems with that. Yeah, I don't think they were that close before.
right.
Oh, no, lots of people were nominated from the floor last time.
Who?
Like, I was nominated for the floor for vice chair. I wasn't on the ballot for vice chair.
Yes, but
That was because
And
don't you
also,
think
so
that's
was Kathleen.
appropriate
So
after?
was Kathleen.
Don't you think that's appropriate though? You ran for a certain position, and then after losing,
yeah.
if you hadn't put your name in for both, then you wouldn't be able to run for that. And I just think that. I mean,
Yeah.
I personally think that.
And
that's
nominating Kathleen, I didn't see a problem with
But
that.
that's what
I
I'm
was
saying.
still-
They do come from the
So
floor.
I would like to not change that practice that we've been doing
So
for the
do you
past
want
2
to
years.
just continue with what we're doing now?
Mhm.
Completely?
Not the voting part.
Not the voting part, yeah.
The nomination part was fine.
Obviously did, so you can, but it's not legal.
No, the part that's not legal is the part that we didn't release the ballots after the fact. So
Well, you'd have
we
to have
still
your
would have
names on
to
'em.
do that.
Well, you'd
We'd have
have
to put
to-
our names on it. It wouldn't be
I don't know
anonymous.
And I don't know if there's been any research done on this, but I'm not sure even that satisfies a public vote.
It's going to go on.
I was just going to say, Dave Thomas, who's not here today, he did do some research as to what the board is
It has
required
to
to
be.
do. It was his conclusion, based on the language of the Open
It has
Meetings
to be
Act,
moved.
that the minutes need to
You
have
have to
the
make a
names of each board member and how they voted.
Okay, so we can still vote anonymous, but at the end, it's got to say Board Member Bolter voted for.
That was his opinion.
But in the spirit, and I guess in the spirit of a transparent and a democratic society, I would like to be voting publicly. So it maybe is the baseline of what
Well, you are voting publicly.
Well, in a very convoluted, hidden way. So I feel like I'm just saying I would like to be as transparent to my constituents as possible about who I'm voting for.
To protect how voting is done, we go into a booth to vote. Why? So that you're not swayed or what have you. So I would like to keep that way, and then we can release it after.
Let's make motions, shall we? Elisa?
You have a computer.
I move that we put all three options before the board, with the preference of option 2.
Do we want to change the language in 4 and 5 about the?
Yes, please.
Take that out.
Yes.
That's choosing the number of vice chairs in advance
and
making people file in advance.
Right. Yes, I'd like to take that out.
I would like to take that out. Yes.
What is the advantage to waiting and doing vice chairs at the last minute?
So that the newly elected board members can have a say on how they would like their board to function and not have to do it based on the ones that were going out.
Could we
I don't
meet
feel like I'm
together,
in a position to make that decision for somebody that just got voted in.
I guess it doesn't matter if they're just going to be able to pop up on the floor and do whatever they want to do.
Right, as we've been doing it the past 2 years.
So it sounds like they want to roll those back.
Maybe what we should do is give both. I guess we need to. There's 3 things here, so there's 3 options here, right? Plus, then we have these other 2 options, and I think that they may need to all go to the board separately.
So right. If the recommendation you want to make is to use the preferential voting, you should recommend that the board adopt the bylaws revision 1 and the board policy 2002 revision 2.
Okay. What he said. However,
with also, if you want to, striking the language changes to 4 and 5.
Well,
yeah. So bylaws. What was it that you said again?
Bylaws revision 1.
Okay.
And board policy 2002 revision 2. And then if you want to strike the language from 4 and 5 to refit to board policy 2002, you'd also want to make that motion.
Chair.
Okay.
I'm wondering if there's a way that we could put in on election years, because I'm okay with the month in advance when it's not an election year.
I'm just not okay with it being an election year.
And then you might run into problems if there were ever an appointment or something, but it usually wouldn't necessarily be that time of year. And if we could have it so that they can submit early, but then also have the opportunity to be nominated on the floor.
Like how we've been doing.
So I don't know the proposed amendment. This isn't my expertise on how to do this.
And my thought is, like I said, I think people should have information on people before they just pop up and
but
are voted. I think
strategy-wise,
that would be.
There's different strategies that are in play. We've seen
Right.
different strategies
And
happen.
if you're-
Yesterday in the board meeting, we saw a strategy.
Well, that's true. But you also see, and I guess it changes your strategy. I'm looking at it not as a person who's running, but as a board member, looking at candidates, so that. And that's how I'm looking at it, that I would rather have some advance notice so that I could look at candidates and talk to them and see what their positions are on the issues. And so, especially if we're going to do ranked voting, I need to know what their positions are on certain issues before.
The board policy would give each candidate a chance to address the board, and so that's where you would have the chance to let them give their policy preferences, and presumably you could ask questions.
You could ask questions then too. That's how we did it.
I think, and maybe that's been up to board leadership. We haven't always had the option to ask questions. It's been like they've got 2 minutes or whatever, and they can and they can do it. So I think it's just kind of up to, so I think if we want to ask questions, then we can probably need to put that in the policy.
Okay, then I'd like to amend my motion to put that in the policy, that we, just to make sure that that's part of it. Because you're right, some board leadership, I don't necessarily agree with this move that everything has to be streamlined and to prevent discussion, or that everything has to be decided upon before we walk into a meeting, because I believe we owe it to the public to have these dialogues open so that people understand where our thought processes are coming from and how we're drawing our certain conclusions. So I'd like to have that as part of it. But I also wanted to respond to Chair Hansen's dialogue and think about it. As you go to vote for someone, if they didn't put their name in advance and you didn't get the opportunity to ask them the questions, then you're likely not going to put them in preferential order as someone that you would respect because they didn't do that. And that would be your call as a board member. And so it wouldn't really matter if we allow it, because that's something that you think is important, and so you're not going to likely look at candidates that pop up.
So we have a motion on the floor, but there's no amendments to the motion.
I amended my motion. I don't know if that's allowed or not by Robert's rules.
You can amend.
I can allow that. But I haven't stated the motion yet, because I'm not exactly clear on what the motion is yet. So the motion isn't in play till I state it, and so I need to know exactly what the motion is so I can restate it.
As Ben
said. Can I restate it as I understand
it? And then can you, Matt, add the amendment?
I wrote it down too.
So as I understand the motion, it's to adopt revision 1 of the bylaws, revision 2 of board policy 2002, that we would strike the changes to paragraphs 4 and 5 in 2002 revision 2, and that we would add a provision in paragraph 5 that board members can ask questions after the candidates give their statements. And I'll come up with some language from that unless you want something specific right now.
Okay. Okay, so the motion, as I understand it, is that we send revision 2
of board policy 2002.
Right. To the board as our recommendation. That we send all 3 of them, but show that revision 2 is our is the committee's recommendation.
No, it's bylaws revision 1.
In addition to revision 2 of board policy 2002. Right. Sorry for all the numbers here, but she's correct. You're correct.
Yep.
Okay, so revision.
But it also includes the bylaws change.
Right.
Okay, and it would include striking 4 and 5.
The changes to 4 and 5.
The changes to 4 and 5 in 2002, and adding a provision to ask questions. Right.
Can I ask a question more specific but general?
Okay, hold on just a minute. Is that?
And the adoption of revision 1 of the bylaws.
And adoption of revision 1 of the bylaws. Got that?
I'll help you with that, Sybil.
Okay. All right. Now, discussion.
Why do we have to have the process spelled out in both the bylaws and policy?
That was a decision that was made last year because
by another board.
Yes. So
okay, that's all I need, Angie. Thank you.
Okay. Any other questions? Concerns? Okay, so we're going to recommend this revision with those changes that I stated. Right. Yep, we're going to do that. But I want to make sure nobody has anything else to say. You're all good?
No, I'm not good. I'm not going to vote for it. I just think it's overly complicated, and I just think we need. The only thing I care about is that it's a public vote, and it's not embodied in this. So.
Okay. So, all in favor, say aye.
Aye.
Opposed?
No.
No. So it will go to the board without recommendation. There you go. We knew that was going to happen. Thank you, Lorraine.
Make a comment real quickly?
Angie?
I'll mock up the changes.
That's what I was going to just say is let's be prepared to have a version. Maybe we could do a
We'll do a
revision
version
2A.
Revision
Yeah, revision 4,
probably would
maybe,
be
yeah.
good.
Yeah, and do that in revision 4. Yeah, that'd be good.
Okay. Anything else? All right. Wasn't that fun? Any other bylaw changes that we needed to talk about? Was that the only thing we were talking about?
There were a couple of technical changes
It
that
seemed
are
like
included
were
there from
a
Lorraine.
few other.
One is just the requirement, taking out the requirement that the board chair has to appoint members to UCAT. That's no longer the case under the statute. And then it adds that a couple of other committees that the chair is required to appoint members to
It seemed
by
like
statute.
I had a question. And weren't we going over section 5 this
6.
month? Didn't it say, let's see, I was looking, Ben. Section 5, Section 6, and Section 8A is what it says that we will be discussing.
And then I have a question about the appointment language.
Section 5,
Oh,
Section 8.
we just in answering Linda's question, we were originally going to talk about some changes to when the board could schedule its meeting schedule for the upcoming year, and then we were directed to leave that out. So that would have been 8A. I don't. If that's on the memo, I guess you could still talk about that. Section 5, there are some changes from, I believe, the month before. I'm not sure, can't remember if we talked about that section or not.
I don't think we talked about that section, and I have a question on it.
I had a question
as I was
earlier,
looking
Lynn.
to. Do you have a question too? Let me ask my question, and then we'll see. So we're talking about, I see that we removed on page 4 approval of charter school applications and charter school enrollment limits.
No, we just moved approving charter school applications down a few.
But you moved the applications, but not the enrollment limits.
Angie, do you remember why we did that?
No, the enrollment limits it's in rule. That is a good question. Did we put the enrollment limits somewhere else?
Not that I could see, and that was my question. When I went through, I thought there might have been a reason why we took that out, but I couldn't see that it was in there anywhere else.
I don't remember. It's been a couple months since we added these possible changes. That's one of the problems with carrying all these over from month to month.
Yeah, I know.
I still have a question when you get around to it.
Okay, so is there any? Do we need to just change
pull it
that
in
back?
if you want? Just bring back. We could just do an approval of enrollment limits as described in board rule, and cite the board rule. I think there's a statute
are we,
on enrollment limits.
Hold on just a minute, Carol. So let me make sure. Are we approving this time, or do we need to?
No.
Well, it depends on.
Or is this just for our information, so you guys can go back and make changes?
This is how we've been going month over month. We've been kind of tracking the changes that are suggested, and at some point,
we're going to approve it all.
Them. I mean, I think at some point it might be good to tackle some of these and get them approved rather than tracking them every month. But also, if we're going to be voting on some revision of the bylaws, depending on how the board comes out on the elections process, the revision could include these as well.
Okay, so I would like that put back in, I guess, if you guys would make a note to do that. Okay, Carol?
I just would like to have all of the stuff that's in statute or rules someplace else removed from the bylaws. Doesn't seem necessary to be repeating things in the spirit of streamlining that are already, that if the statute says that the superintendent shall appoint, I don't think we need to have it in bylaw. So I'd just like to take everything out of here that's not, that is someplace else, and because it just creates confusion.
What we're trying to do with our rules.
Like the example, yeah, exactly. And now we're adding another layer with policies. So let's not repeat in any of these what's otherwise in a statute.
Elisa?
Or something else.
I can appreciate that. I just want to make sure that it's very clearly noted, and if possible in our documents linked. I know it can't be at the rules website because often people don't go to the statute, and so then they're only looking at the bylaw.
And that would be a great argument for something I've said. We should have more statutes in the rules so that people could actually read them and make sense of them. But we've got to choose one or the other and not be so schizophrenic, is my feeling.
Okay, Elisa?
And the reason why that's been in practice is because of recommendation from the legislature and how they want us to put it, right?
Okay. Are there any?
Because I agree with you.
So this is section 5. If all of you, does anybody else, does anybody have any other questions on section 5?
They don't do it.
Any comments on section 5?
Can I just make a
Angie.
comment? So there are pros and cons to repeating statute in the rule. And
Having deja vu here.
we are not opposed. Ben and I are not opposed. If you would like to make a proposal and take this issue to the full board, I think we've talked about it in this committee. We've talked about it in task force. We talked about it in subcommittees. And just so you know, we are doing what was directed not only by a former board, but it is what the Administrative Rules Committee directs. It's their rule drafting manual. There are definitions of what a rule is and what it isn't in statute. And the definition of the rule in statute does not say to restate statute, because the cons of doing that is then you have an agency reinterpreting the statutory provisions. If the board would like to direct Ben and I to put statute into the rule, we can do that. And that's not the agenda item for today. I would be happy to put a board docs item on for either this committee or the full board to, and if you want to direct Ben and I to start putting statute into the rule, we can do it. I would just say two things. One, we may get called up to Administrative Rules Committee for that practice. And number two, we could be, somebody could say we're trying to change the interpretation of the statute. But if we just wanted to simply dump the statute into the rule, we can. It will make the rules very lengthy. For example, the bullying rule is an issue where we talked about it. There's a whole act on that, which would be multiple pages. So, but we're not afraid of the conversation, and if that's the direction of the new board, we'll do it. And I would be happy if you'd like me to prepare a board memo for that for next month. I'll do it.
I think we need 2 board members who would want to have that done, and I'm not in favor because I've gone through all of this with you before. So,
Linda. Since I'm the one that brought it up, that's way bigger discussion than today. I have mixed feelings about it too. I just think that it makes the administrative rules not very user friendly, and I don't. My challenge is, I would say sometimes it's a good idea, sometimes it's not a good idea, which is not a very helpful standard. So I don't have a strong opinion about it today. I don't have a strong opinion in terms of doing it. I just would like the rules to be more user-friendly, and there is that dilemma. But I think the policies are of our own, going back to our issue for today, the policies, the bylaws are of our own creation. There is no need, and there's only 15 of us mostly to whom they apply, and some office staff. So that's why I would like those to be simpler and not be taking this 45 minutes when all of it's mostly provided for in statute already.
Okay. Do you have any other questions, Ben?
Just if there's other changes you wanted.
Any other changes anybody wants? Angie? Mm-hmm.
If you'd like to do that, you could just strike all of 5B. Essentially, that is what 5B is.
There's a lot of sections in the bylaws that are like that.
Well, but if you're looking at this section.
I think it ought to be a comprehensive overhaul, not just piece by piece.
And I think, Carol, if you want that would be something you would take to board leadership and ask them to put on our agenda. Okay? I think that's the way the procedure there. Okay. All right. Let's go to R277519, Educator Professional Learning Procedures and Credit. Hi, Diana.
I haven't been in this committee for a while. It's kind of a nice change. So really, the reason for well, you are. It's true. I won't argue with you. So I believe that this rule was up for continuation, and Ben forwarded it over to us, and we realized that there were some things in it that weren't really very clear about what the rule was actually governing. And so what we've done is we've gone through in order to provide clarity for that. So this rule refers to professional development credit that is given by this office that is used by LEAs in a variety of different ways, but one way it is sometimes used by some LEAs is to recognize credit the same way they would recognize university credit for pay changes. For steps and lanes. And so we wanted to make it more clear that that was the purpose of this rule. And then it has a part we're not changing is what the criteria for that is. So really the changes were to make that clear. And also one of the challenges now that we're all the board is really making it clear like who's approving stuff. So if it says board approved, then we want the field to understand that that means that it has come before you and has been approved. And so we've talked about it as board approved credit when in fact it wasn't, and I don't think you want it to be because we're talking about a lot of professional development courses that are approved normally by staff. Right. So we even though Angie advised us we normally don't put USBE in, we didn't know exactly how to make it clear that it's board approved credit, but the courses are approved by staff, and so that was what we were attempting to do.
Okay. Any questions? Whoops. Sorry.
That's the only nature of the amendment?
I believe so. I think that was it. Yeah.
Okay.
So
Lisa?
on line 18, I just, for my own clarity, is the superintendent referring to an LEA superintendent or is referring to here?
Staff.
But it's actually board staff.
Okay. Well, because before it said an LEA, so that's why I'm trying to.
Yeah, it was one of the things that when we started reading it, we were like, LEAs have never approved the credit because it all happens from this office. And so we really don't know why it ever said that, to tell the truth.
Okay. Any other questions on that? Okay. If not, we need a motion. This is 519, or 277-519.
I move that we approve R277519 as amended on first reading and send it to the board.
It's not a continuation, is it?
It was continued in February, so we're good there.
Okay, so the motion is that we pass R277519 as amended on first reading and send it to the full board for their, for consideration. Thank you. Any other comments? Okay, all in favor? Aye. Aye. Any opposed? Okay, that's unanimous. All right. So a little discussion here in the middle, and I apologize. I have a really bad headache right now. So if I'm lapsing, that's why. So we talked last month. There was some confusion. Some people came and talked to me after about moving things around. And did I think our committee wasn't smart enough, good enough to take up some of these rules? And so I just wanted to clarify that a little bit. And I should have explained that after things are assigned to us, a lot of us board chairs will look over what we've got. If we feel like another committee has more expertise in that area, we move things around. And it's not necessarily always moving things out. Sometimes things get moved into our committee if they feel like it is better here because we have expertise in certain areas, because we see rules all the time. We see charter schools. We see those things that we see all the time. Another committee might get and might not know what to do about it. Just so that we're clear that I think you guys are doing great, honestly, especially for all being new board members. So, and the reason why I say that now is because this is one of those early college coursework committee. This is something that was moved to our committee from standards and assessment. And they are coming back to report. We asked them to do things for us, we asked them to do some things for us, and they are coming back to report on. So if you guys want to come up, we have Jennifer and Garrett. Is that right? And I've got to tell you that this got put in standards and assessment, and I said to Laura, "Oh, that's them coming back to report to us. They got to come back over." So we're happy to have you guys here.
We're happy to be here. Thank you for having us today. So what we're reporting, we're also asking for an action as well. Back in the December 2016 board meeting, when we were reporting the legislative reports, which ironically was transferred from standards and assessments to law and licensing, we were looking at some of those social dynamics and some of the numbers with enrollments, and we were noticing that among underserved and underrepresented populations, that they weren't even meeting the metrics of what the populations were statewide with students. And so it was requested that we put together a plan to bring to the board. And so far what we have is we decided we needed to build a framework. Jennifer and I had looked at some data, and the more data we were looking at, the more we were seeing that we weren't meeting those population metrics as far as students enrolled in early college coursework, which can include International Baccalaureate, advanced placement and concurrent enrollment, as well as honors courses throughout not only their high school but middle school experiences. And so we were seeing a lot of those deficits. And so before we could get started with a comprehensive plan, we needed to build a framework, and that's what we're bringing to you today is the framework. And so as we met with the general committee, the early college coursework committee, we have built this framework, and what this framework has is we've parsed it into 3 pillars, and those pillars are pillar 1 is students and parents, pillar 2 is teachers and school counselors, and pillar 3 is school and policy. And the more that we started digging and looking at data and working with stakeholders from around the state, which included counselors, teachers, administrators, school board employees, etc., we noticed that we needed to parse this out not only into these 3 pillars, but each one of these pillars needs a subcommittee. And so what we're bringing to you today was this framework that shows you what these 3 pillars are and what our plan is in the time frame. So as far as the time frame is concerned, we're looking for a committee approval today, and waiting till November for the full board approval. And once we get the full board approval, approving of this framework, we want to move forward with inviting the stakeholders to develop the subcommittees, and a subcommittee for each one of these pillars. And then throughout that time, once we begin the 3 subcommittees, we want to have everything wrapped up in June as far as the subcommittee practice recommendations. But one of the things that's really important is we're advocating for change, and change is going to take some time, and some of that change is going to require some board policy changes as well as some legislative changes. And as such, we're looking at August 2018 to have those board staff policy recommendations for you. And so that's what we wanted to share with you today.
Okay. Questions? Thank you. Questions? Elisa?
I just want to, can you just repeat what you're asking us for? I mean, you're bringing us this information, but what are you wanting from us today? I just want to make sure I understand exactly.
Sometimes from a different voice, maybe. Yeah. So basically, we were charged to look at how our low-income and diverse populations were being served in schools in terms of early college coursework, enrollment, and success in those programs. What we found is there is a deficit between even their enrollment in these programs and their success levels. So for example, about half of the Hispanic students in our population are actually engaging in this kind of work, and so the populations aren't representative of the population we have in Utah. So this is basically a proposal to say, here are some things that we, from talking with these committee members, would recommend us doing some more investigation and bringing you some concrete action and strategies and steps to moving forward. So for example, the last one on the pillar 3 is evaluate the current allocation of resources for early college coursework. So currently we send out money to each LEA who uses that to kind of enroll students and support them in advanced college coursework. We might want to look at opportunities to say, you need to use a portion of those funds to really work with getting your underserved populations enrolled in your programs and to achieve success for those students. It's not enough just to enroll students. We also have to think about how do we make sure they're successful. So those are opportunities that we're not bringing you like concrete today. We wanted to have the subgroups or the committees break down to each one and come with specific getting into the weeds. We kind of got into just the higher level information, and coming through these work groups would be specific recommendations based on board policy, legislation, or just best practice around how we get more students of diverse and low income status into coursework that can engage them in that kind of college and career track mindset. And some of it's teacher beliefs. We have to change some teacher beliefs around what kids can and can't do in schools. And so looking at coming with some specific suggestions around what that work might entail.
Elisa?
Right. So you're asking us to make a motion or just to say this is nice, we think this is a good idea?
Do we need a motion, Angie?
Yes. That's what I was asking.
Yep.
But you could take a motion to support the work. Say we reviewed and
Yeah.
support stuff.
They, if you guys will remember, you guys were really new then, and I think you were just visiting. But when we heard their report, we said, "So what's your plan?" And they went, "Oh, we'll go make a plan." So now they're coming back with the plan. This is their plan.
Here's our framework.
The framework for the plan, so that they can improve outcomes for those students. Carol?
I just want to say I really appreciate that what you're doing. Obviously, I support it 150%, but I also like, Garrett, your point about you've talked to people in the field, you've been exploring what's happening prior to bringing us what'll probably maybe be some rule changes, I'm not sure, maybe some different use of funds, but I really, really like this process where the work is being done in advance, so we have information, we have data, it's not sprung on people, whether it's teachers, administrators, parents. I very much like this and support the process that you're using, and agree with your end result more than that.
Thank you. And the goal with the subcommittees is to, that's our boots on the ground to dig even deeper and to bring that back to you. Yeah.
Okay, so I have a couple questions. Do you guys want to make a motion, or just want to tell them, good job?
Do good work.
Go for it. We don't need it. We don't.
I don't
and
think
then
we
my
need a
other
motion.
question is, since this originally came from standards and assessments, and we asked them to come and report, do we want to now have them go back to reporting to standards and assessment, or do you want them to keep reporting to law and licensing?
Well, originally, when we went over the 2016 legislative report, it was in front of Law and Licensing, and Law and Licensing was the one that established us with this task. And Jennifer and I reported in April to Law and Licensing as well as about what the progress we were making. So, I mean, that's just
yeah, you're okay with just leaving it there.
I'm fine either way.
Okay, I think you guys are doing a great job.
And I can definitely see some
Great,
connections
thanks.
of where this work will go that will be in your wheelhouse for sure. Yeah, there's
Okay.
some policy work that will need to be done.
And are you guys going to ask for policy changes this legislative session? It will be the next one.
Not to be strategic and intentional the way we want to be. There's rash decisions we can make because we know there's certain things that need to be done, but to be really strategic and have your support and feedback and to help the field be kind of ready for those changes, I think intentionality overwhelms the
That'll
need
be
of
great.
rushing. So.
Okay, thank you so much. You guys are great.
Thank you.
We appreciate your work.
Oh, and I would be remiss to not say Christelle Estrada and Momi are both involved in this project with us, and they're
Yes, and they've been
Thank
stellar
you,
in
guys.
helping us build
Thank you very much. You guys are doing great things.
So,
I know that it's, we always find that it takes a lot of effort to move the ship, but, eventually it does. So we appreciate it.
Thank you.
Thank you. Okay, so, okay, we have a motion to adjourn. All in favor? Aye. Okay, we are adjourned. Thank you.